The cause of action, if any, had arisen on passing of the aforesaid order of reinstatement of 26/5/2010. Though it appears that the petitioner had submitted representation on 28/6/2010, order dated 24/9/2010 makes it clear that the appeal of the petition was duly considered and further review of the appeal after such consideration by the highest appellate authority was not possible. The petitioner did not approach this court with any grievance against the said order at that time and rather kept on representing from time to time. Petitioner has tried to contend that a fresh cause of action has arisen after passing of the order of 23/12/2019. It has also been additionally urged that such rejection is not by the competent authority. This court on perusal of the materials has noted that the appeal of the petitioner was rejected in the year 2010 itself, against which no proceedings in any court of law was instituted. Though the petitioner claims to have filed a number of representations, it's strike law that mere submission of representation would not extend the period of limitation. As regards the order of 23/12/2019, the same is only a communication after consideration of the representation dated 21/11. Such communication cannot be treated to have given rise to a fresh cause of action, as cause of action, if any, had arisen in the year 2010 itself, and when the order dated 26/5/2010 was passed. Nadir Singh has been quoted. Under the aforesaid facts and circumstances, this court is of the opinion that no relief can be granted. Petition is dismissed.
Obliged.
Record as a video. As regards the objection taken that the writ petition is not maintainable, this court is of the opinion that two candidates cannot join together in challenging the appointment of a selected candidate when the number of posts is one and there would be an apparent clash of interest. However, this court has been informed by the learned counsel for the petitioners that the petition number 1 has in the meantime crossed 55 years of age and is outside the purview of consideration, and therefore the present challenge would remain only for the petition number 2. From the context of the challenge from one petitioner, namely the petition number 2, issue is required to be examined. The advertisement has the following condition. It is clear that 15 years of experience as assistant professor is not only confined to teaching, but it also extends to the field of research and administration. It is not in dispute that the respondent number 6 was the head of the mathematics department of the Joya Gogoi College for 3 years. He is also the coordinator of KKHSOU for 11 years. Joya Gogoi College, which has been arrayed as respondent number 7 in his affidavit dated so-and-so, has given the history of the service experience of the respondent number 6. It has also been stated that respondent number 6 was appointed in so-and-so and approved on so-and-so. Affidavit has also been given a chart regarding the number of students and a clear statement that apart from teaching in his own department, respondent number 6 has been taking classes in mathematics for BPP, BA, and BCA. It is stated that he has taken classes under KKHU and he is coordinator for 11 years. Respondent number 6 in his affidavit in opposition has submitted that apart from the Department of Mathematics, he has taken classes in economics and BBA, wherein mathematics is an integral part. He has also highlighted that the RTI reply was only in respect of graduation course, wherein the aspect of undergraduate course has not been dealt with. The chart annexed in the affidavit of the respondent number 7 clearly shows that respondent number 6 has met the requirement of 15 years of experience as per the advertisements. There is no objection or challenge on any other aspect of the selection, and admittedly respondent number 6 had secured more marks in the selection. It also transpired that in said selection there was a nominee of the university. In any case, the constitution of the selection committee is not the subject matter of challenge. The petition is dismissed.
Appear on behalf of the respondent. DYSDI is supposed to appear, but due to some personal difficulties, he cannot appear for.
Who will be appearing?
DYSDI, Ranjit Tipsud. So,
My lord, we don't have objection. Yesterday informed that today they have some difficulties, my lord. So, Lordship will permit, my lord, on Friday, my lord, because this is appeal, my lord. This is relating to, my lord, rejection of bail, my lord. In this
Friday it will be difficult. One of us may not be there. Will have it on Monday?
Motion meeting Monday. Okay. My lord, I don't have any objection, but I think
No, Friday is not be possible.
my lord, from Monday, I think this motion day, my lord.
No, division bench will hardly have any.
Then Monday, my lord.
Monday? So?
Yes.
No. on a request made on behalf of the Deputy SGI who is appearing for the respondent, matter is adjourned to be listed on Monday next date, huh?
Mandeep.
Item 10.
May it please your lordship, lordship, I beg to mention item number 3 and 4, your lordship. Lordship, the matter may be taken next week, your lordship.
Let's go after the vacation.
After vacation.
Yes, it'll take some time. You're there, Mr. Okay, okay. Let's go because it'll take some time. This bench is
Yes,
a very
it will take-
temporary
There
bench.
are about 20 witnesses. It will take time.
On a request made on behalf of the appellant, or these are two appellant. The matter is adjourned to be listed immediately after the puja vacation.
May I please, Lordship? Lordship, I beg to mention item number 12, Lordship.
12.
It's a series matter, Lordship.
Yes,
The engaged,
12 is with 11.
12, Lordship.
No, 12 is also with 11. It
Yes,
starts
Lordship.
from 11.
From 11 to 15, it's a series matter, Lordship.
Yes,
So in 12, sir, Lordship, we didn't get the paper book, Lordship.
same judgment.
Same judgment, Lordship.
Yes, who are appearing for the other matters?
Other, we have received the paper book, Lordship. And for item number 11, Lord.
Any other council has any difficulty?
Item 14 is there, Lord.
I am for item 14. Lord.
I have informed, Lordship, for item number 15, they also not get the paper book, Lordship.
No, you will be supplied with the paper book. That's a different matter. But yes, other councils, what do you say? Supply the paper book and have it together?
Lordship, we take up together, my lord, all the items.
Together, okay. You are in item number 12.
Well, Lord,
What is your name?
M. Hussain, Lordship. One difficulty, Lordship, my senior, Mr. M. Bora, he is not present, Lordship.
No, no, today we are not having.
Okay.
We'll ask the paper book to be supplied to you and have the matters listed immediately after the vacation.
Lordship.
Okay.
Sure.
And who else not got paper book?
Item
You said
13.
somebody else also has not got paper book. 15.
Okay, my lord, in this matter, my lord, paper bill was not ready. So earlier occasion, my lord, the honorable court was pleased to take hear the matter if it is not ready. So my lord, in the note in the office note, my lord, it was like that it will take 4 weeks time. Maybe my lord, in the next day it may be ready.
But some of Mr. Das has
It is ready, my lord.
Paper book
I have
is ready.
responded.
Already
They have
supplied to us.
received.
My lord, the prosecution has not received.
Okay, okay, that's good. You have informed. This court has been informed that though the paper book has been prepared, comma, the same has not been supplied to all the councils.
My lord, we have received.
No, supplied to a few of the councils appearing, to the councils in
Item
Criminal
number,
Appeal 258 of 2023, and including the council of Criminal Appeal 258 of 2023. We cannot record the this thing. P. Kotoki, if he's not there, he might have received it. So it said including. Okay. Registry to supply copy of the paper book to the remaining councils who are connected in this series of matters in these DHS. Matters may be listed for hearing immediately after the
Lordship.
Puja vacation.
Obliged, if you.
May I please, your lordship, I'm appearing on behalf of SC Biswas. Here in this case, one of the co-accused, accused number 1 has expired, lordship, on 7th May this year, lordship. Here is the death certificate.
Now, how does it matter then?
Yes, lordship.
How does it matter?
Means,
Will it make any difference in the hearing? It's a criminal case, conviction. One of the accused has passed away. How does it matter? You argue for the other. It's a common
Okay.
judgment, isn't it?
Yes.
Yes, Lordship.
Paper book is there. It's not a matter of substitution or anything else like that. Now, if there is any legal implication, tell us.
No, it will be abated if the like any legal heir wants to substitute themselves.
Now, when was
Because
the
it's a
death?
appeal against conviction, my lord.
When was the death?
The 7 May 2024 this year.
He's passed away already. What was he doing?
He was
Was he a
inside-
government servant?
No, Lordship.
Then what implication will it have? If he had been a government servant, then the question of
Obviously.
something would have come. Now, what remains? You wanted to do some work, other matters are all being adjourned. What work will you do? Okay, you take instruction, proper instruction. or
Yes,
what-
Lordship, I will take proper.
When? Tuesday next? Tuesday next. We'll have it for Tuesday next.
Right.
Madam, you're there on record.
I'm appearing on behalf of SC Biswas, Lordship.
Your name,
KLR Yantan.
please give your name. Ms. So-and-so learned counsel appearing on instruction of Sri SC Biswas has submitted that instructions are required to be taken in view of the expiry of the appellant number 1.
Yes, Lordship.
Appellant number 1.
Yes. Abdul Khalik.
Also heard Miss Me Bhiyanan, Senior Counsel and APP, Assam, Tara. List on Tuesday to enable obtaining of instructions. Tuesday on date given.
With physiology. Well, this is a reference under TRPC 375. So, my lord, we have to decide under section 376, 3796, my lord. In Nagaland Liquor Total Prohibition Act 1989, there are 9 cases. Your lordship will find at page, my lord. There are 9 cases, my lord. They were FIR was lodged. Charge sheet has been submitted by the police. Page 8, your lordship kindly. Page 8. Page 8.
Page 8.
Page 8, man. These are the 9 cases. 1, 2, 3, 4, 5, 6, 9. In all, your lordship got it, page 9, man. 8.
8 is.
And in all these cases, IO investigated the case and filed a charge sheet against the accused person under the various sections of NLTP Act. So charge sheet has been submitted. Now, my lord, it is before a magistrate, and magistrate, my lord, he cannot, magistrate cannot take cognizance because of it there is a specific bar. Your lordship will go to page, my lord, 26, my lord. Page 26, my lord.
26.
Page 26. My lord, that is a part of the act, my lord. Act is that act is started from 17 and but 11 portion is page 26, my lord. Page 26, my lord. Section 43.
Yes, please read.
Page 26, section 43, cognizance of a offense. No court shall take cognizance of an offense under this act unless a complaint in this regard is made by the director, prohibition, or any officer authorized by him. Here in this case, my lord, charge sheet has been submitted. Now, my lord, this London magistrate is in dilemma. he cannot drop it, he cannot proceed, my lord. Because why he cannot drop it? Because it's a warrant procedure case. Because punishment is up to 3 years. So it is a warrant procedure case, my lord. He has to take cognizance. But if it is a, my lord, summons procedure case, he can drop. Because it is not by a competent person, it can be dropped. So that's why London Magistrate send it to for this honorable court for reference, my lord. That reference is, my lord, your lordship kindly see. Page 2, my lord. Page 2, my lord.
This 9 cases, they arose from which, what
My
was
lord.
the cause? How did it arise?
My lord,
The 9 cases
my lord,
in which this charge sheet has been submitted.
My lord.
In the stage of taking of cognizance, how did it arise?
there,
Who had lost the report?
that lost before the police station, some FIR has been lost. Probably
Oh.
that record, I do not know, my lord. Probably
On the basis of FIR,
FIR,
not on the basis of a complaint by the director prohibition or
My
any
lord.
officer.
not by them. And police investigate, file charge sheet. So in this situation, my lord, the reference was made before this honorable court, whether a magistrate in police registered warrant procedure case can drop or stop proceeding at the stage of taking cognizance. Against,
What are you reading?
page 2, my lord. What is the reference made before this honorable court, my lord? Para 3, my lord.
Yes,
Para 3.
yes.
The learned judicial magistrate first class Tuen Sang in his order has made a reference to this honorable court on the following question of law. Whether a magistrate, the police registered warrant procedure case can drop or stop proceeding at the stage of taking cognizance against the accused in NLTP Act case, since there is an express bar for taking cognizance except on a complaint made by a director on prohibition, an offense authorized by him under section 42 of the Act. So although reference was made whether he can drop it or whether he can proceed. He cannot proceed, he cannot drop in that situation, my lord. Because why your lordship kindly see the warrant procedure case. No. 258 CRPC, your lordship kindly.
Here, piche khan de. Our-
CRPC 258.
Yes.
The power to stop proceeding in a certain cases. In any summon cases instituted otherwise than upon complaint on the magistrate of the first class or with the provision of sanction of the chief judicial magistrate may reason to be recorded by him stop the proceeding at any stage of without pronouncing any judgment. And where such stop of the proceeding made after the
You said this is a warrant procedure case.
it's a warrant procedure because my lord,
258, how will it come?
no, how now? That's why, my lord, that why he is because he London magistrate cannot, my lord, stop this proceeding. Because it is not a warrant procedure case. It is not a summon procedure case. So that's why I'm pointing out that 258, my lord. It's a warrant procedure. Why it is a warrant procedure, my lord? Punishment is up to 3 years. Punishment, my lord.
No, punishment is given on the same page, page 26.
Yes, 44. Section 44, penalty
Section
for,
44.
yes. Apart from the purpose of this, shall convict be punished for each such offense with imprisonment for a term which may extend to 3 years and also fine, also be fined. So, my lord, CRPC 210, my lord. So CRPC, my lord, section 210, my lord.
Just a minute. Convert someone to something. 210,
Section 2, subclause 10, my lord.
yes.
Warrant case means a case related to an offense punishable with death, imprisonment for life, or imprisonment for term with exceeding 2 years. So that's why it is, my lord, under warrant proceeding.
Where are you reading? 200?
200, not 202. Definition, my lord. CRPC 2,
Okay. 2.
2.
You are into the definition part.
Yes, my lord. 2, subclause 10,
210.
210, my lord.
Okay. This is not 10, this is X.
It's Roman X.
No,
But-
it's X. It's not 10.
Oh, yes, my lord. Yes, X. Sorry, my lord. Yes, sorry. X. In Roman, it's
It's not Roman 10,
Roman.
it's X.
X. Yes. It's X. Sorry, my lord. The warrant case means a case relating the offense punishable with death, imprisonment, life. So, from the punishment, it is clear that it is a warrant proceeding. So, under this situation, my lord, an offense was made, and apparently, my lord, from the affidavit filed by the government of Nagaland, there's a affidavit filed, my lord.
Is NLTP the only act involved in this case, in this case?
Yes, my lord.
Offense is only under NLTP.
Yes, my
No other
no other. my
act
lord.
is involved.
From the affidavit and all, my lord, I came to know that, because the code was not called for.
May I
Yes,
make
yes.
a small submission? Actually, the government is contemplating to lift a ban on total liquor prohibition. It's still under talks. It has not reached a final decision. So whether this will have any impact on this case or not, if the ban is lifted.
You have some instructions on this?
No, it is in paper and
No,
news
no, no.
everywhere.
You are
but-
appearing as a counsel for the
Yes.
government.
But
If-
in our affidavit, the excise department has come out with a notification where it has empowered all officers, OCs of all the police stations. But our affidavit again says, seeks a direction from the court to direct the state to appoint appropriate officers.
No,
That
you
is what
see,
we have
you see
filed.
the definition of in the section 43. It
Yes.
can be by the director of prohibition or any other
Yes.
officer. These FIRs were lodged by whom?
By
First, it
the-
was an FIR, not a complaint.
Not a complaint.
So there's a vast difference between an FIR and a complaint. But the police has to put it the complaint is a file until the magistrate or complaint or before magistrate দিব পাৰে investigate. That's a different matter. FIR কেনেকে root কৰিব এইটো? Fundamentally error থাকি যাব নহয়। মই কেনে বাৰী দি আছো বেলেগ offense আছে নেকি? বেলেগ offense নাই। Madam, do you have any materials to support your first submission that there is a
Then in that case, my lord, I'll have to take instructions. Otherwise, my affidavit stands. For that,
Mr.
let
Mohta,
me take
My
some time otherwise, my lord.
are you aware of any of such? Or you may not be aware. You are acting as for the Guwahati High Court.
Yes. my lord. Since it is a reference, my lord, I am assisting the court, my lord.
যদি সেইটো হয় তেতিয়াহ'লে এইটো আমি আনচাৰ কৰাটো ঠিক নহ'ব নহ'লে আৰম্ভণিটো ভুল হৈছে এতিয়া।
Otherwise, our affidavit,
ৰেজিষ্টাৰ কৰিলে ইনভেষ্টিগেশ্যন কৰিলে চাৰ্জশ্বিট দিছে নহ'ব নহয় ল যদি ভাইলেট হৈ যায় আমিতো ইয়াতে চিন্তা কৰিব আমাৰ ভাল ভাবি লাভ নাই আইনমতে যাব লাগিব What was the kind of offense?
That offense, my lord. Although I have not seen the affair, my lord, but she also not seen, my lord.
You would have memorized the affair if you are appearing on behalf of the accused.
My lord, obviously,
Not only read but memorized.
memorized. I am confined only to the, my lord, reference, but my lord, section,
What is the allegation? Are the affairs here?
no, the affair is not here.
FIR is not here. Madam, you have the FIR copy.
But cases under, my lord, NLT, that Nagaland Total Liquor Possession Act, my lord. So in that case, my lord, they have to come, my lord, very easily at then initial point of time, they withdraw the FIR and file a complaint, my lord, that can be done by the government at that point of time. But even, my lord, there is, if they made a prayer before this authority,
No, see, we have just discussed, there cannot be any other opinion that if there is a fault in the route, everything will go.
my lord,
If it was to be initiated by a complaint by a particular officer or his designee, designated or assignee, maybe another officer of the Director of Prohibition, you cannot proceed.
yes,
The entire exercise of doing an
Will-
investigation,
without
charge sheet,
without jurisdiction.
well, jurisdiction.
Without jurisdiction, they have he has given some reference of the other code also, and that, my lord, Human Transplantation Act, my lord, some.
No, I think a reference has been rightly made. He
Rightly, will, my lord, he is in dilemma, what to do, my lord, I cannot proceed, I cannot
cannot
drop it.
stop.
I cannot drop, other hand, we cannot proceed. So under this situation, what to do?
Are the records have been transmitted or is it a
No, my
reference?
lord,
new
record is not even called for.
record पे call for करूँ कि intermittent net support लगेगा ना we call for the records and in the meantime something happens then we may not
My
be
lord.
we may not be required to answer this also. What was the first order passed
Here, my lord,
here in this
here, my
session?
lord. Yes, my lord. Thank you. Order, my lord, 1/12/2021.
But this is pending since 2021.
Yes, my lord, 21. First order is 9, sorry, first order is, my lord.
We can have the scan copies of the records
My
because
lord,
it is in the court.
my lord,
It is
We
in the
object to
court.
it.
Charge sheet has been filed.
all 9 cases charge sheet has been filed. In their affidavit, my lord, they have stated,
It is from police or
Uh,
photo plus scan copy will say. Wow. Heard Sri
in-
T.J. Mahanta, Learned Senior Counsel, appearing for the Guwahati High Court. Also heard, Madam, your name?
AIR,
Yeah,
AIR.
Learned GA, Government Advocate, Additional Senior Government Advocate, State of Nagaland. Full stop. In this reference made under 395
395.
of the section, and made under section 395 of the CRPC,
Here,
comma, notice was issued on 12/7/2021, pursuant to which pursuant to which affidavit as well as additional affidavits have been filed by the state of Nagaland. Full stop. Ms. So-and-so, the London State Council has also submitted that there is a talk on the policy itself regarding liquor prohibition in the state of Nagaland. Full stop, para, be that as it may, comma. For deciding the reference, comma, it would be necessary to peruse the records, full stop, para. Let scan copies of the case records be called for. Registry to requisition the same. Full stop. List after receipt of the scanned copies of the records. After the receipt from the scanned copies of the records be called for from the court of the chief, from the court of the, from the learned chief judicial magistrate. No, from the judicial learned judicial magistrate first class to Ensang
Mention.
in GR case number subkara likhi diba, ha, it is.
There are 9 cases here mentioned, my lord. Only all cases, my lord, FIR lodged by police constable and offense are very petty, my lord. Some in first cases 24 bottle of beer, cheese, my lord. And in one case, my lord, 46 number of can beer. It has been 6, my lord.
Right, you.
No, rice beer. No, in one case, some other bottle.
Okay.
59 bottle of McDowell rum. Cheese at.
No,
In all cases, my lord, FIR lodged by the police constable. My.
see, we are not, okay, that might have some,
No, he is
Ac-
not authorized, my lord.
otherwise, we are only on the reference, but answering the reference.
Yes, yeah, I was only not authorized. Deputy.
Right.
Interesting. It is. No, very.
May it please, your lord. Lordship, the appellant before your lordship is the wife who has sought for an appeal against the judgment and order dated.
You are the first party.
No, I am the second party.
You are the
It is a-
second party. The proceeding was for what?
Divorce.
Divorce has been granted.
Yes.
You are agreed by that.
I am agreed by that as well as the, I am agreed by the alimony granted by the Lanet court below.
Here for the husband.
Yes, your lord. I think the appellant has no objection for divorce, only therefore small prayer for enhancement of their permanent alimony, your lord.
Yes. Have you taken any instructions? Have you received any, have you reached any consensus?
Lordship, the matter was sent for mediation, and during mediation, Lordship, the husband has declined to enhance. In fact, he has stated that he will bear all the expenses of his daughter, but at the time of his daughter's marriage, he declined to give a single penny. Even, let me go through the thorough facts, Lordship.
Now, what is the alimony?
Alimony, 5 lakh.
You want enhancement of that?
Yes, Lordship.
How much is your claim?
My claim was 18 lakhs, Lordship, and he
18
is
lakhs.
an government employee.
Okay.
And on that consideration, this honorable court has earlier granted us to both the parties to file the assessment liabilities on affidavit as per Rajendra versus Neha.
Yes.
The affidavit has been filed. And
Are you also working?
no, Lordship, I am earning my livelihood by stitching process and earning. I earn 5,000 to 6,000 per month.
By what?
Earning stitching
stitching, okay,
process in my rural place.
Okay,
area.
private employment.
In my area.
Private
in my business,
employment.
Yes.
Okay, nothing to do,
No.
no permanency. Okay.
And Lordship, further, the
What do you do?
Your lordship, I am a retired constable in Assam Police, your lordship. I was retired in this year, your lordship, in the month of February, your lordship. And
Divorce is of which year?
sorry, Lordship,
Divorce is of which year?
2021, your lordship.
no, appeal is of 21, divorce
No,
is
no.
of
Don't you think 5 lakhs is very less?
Your lordship, actually, your lordship, what has happened? I am totally, your lordship, right side paralyzed and totally in bedridden condition, your lordship. And they were staying separately since 1998, your lordship. And so after COVID, your lordship, as they did not appear before the learned family court, your lordship, thereafter the family court, after considering everything, actually, your lordship, various suits were pending between them, your lordship. Thereafter, considering everything, your lordship, the learned family court, your lordship, have given that permanent alimony of rupees 5 lakhs. Thereafter, the appellant, your lordship, she has also.
Now, how much do you incur on your medical expenses?
Your lordship, I have stated that in my asset and
How
liability.
much?
For medical expenses and everything, your lordship, and general expenses, including medical,
expenses.
everything,
Now,
your
you have
lordship.
said, you have said that you are suffering from some ailment.
Yes, your lordship.
How much, what is the medical expense?
More than 20,000, your lordship. As I'm totally paralyzed for in
20,000
my
per
right side.
month.
Per month, your lordship.
And what other expense?
Your lordship, actually all the prescriptions, your lordship, are in the LCR, your lordship. Those I have submitted.
You must be having an idea. How
From
much?
starting
20,000. What others?
Starting from diabetic patient, as he is a diabetic patient also, your lordship. From
Mr. Pal, 5 lakhs is on the lower side.
No, your lordship. Actually, what has happened when the mediation was going on, your lordship, after this honorable court passed, your lordship, thereafter we have said that yes, we are ready to enhance for 1 to 2 lakhs, your lordship. That was his at best capacity, your lordship.
1 to 2 lakhs, 6, 7 lakhs will not do.
Lordship, may I
Just a
submit-
minute, just a minute.
Sorry, Lordship.
6, 7 lakhs will not do in today's context. How will she survive with her daughter?
No, her daughter is married already, your lordship.
Okay, she is married already. You are saying separately since when?
1998.
1998, your lordship.
When was the divorce instituted?
Divorce case was instituted in the year
16.
2019. 19, your lordship. 146 of
Sorry, 1990.
19, your lordship. And since 1998, your lordship, since 1998, I have been paying her, paying my wife, your lordship, more than 7,000
No,
to the daughter and the appellant, your lordship. At first, the first case was instituted, your lordship. That was under section 125, 50 by 1998, your lordship. There, the learned trial court has granted maintenance of rupees 2,000 each to wife and daughter, your
See,
lordship.
those are only for maintenance. Now it's a question of permanent alimony. Permanent alimony is something different.
I have never done anything fault on my part. I have always paid whatever this.
We are not even going to the aspect of divorce. We are on the aspect of how does she make a living?
I have already paid 5 lakhs, your rupees.
5 lakhs is not enough.
But he's totally paralyzed, your lordship.
That is why I have asked you how much expenses.
More
You
than
don't need to earn now to pay her. Whatever you have earned, you'll pay from that.
even
You
your
have got
lordship.
post-retirement benefit.
After retirement, your lordship, I have not received a single penny of my pensionary benefit, your lordship.
That's a different cause of action.
As
You
the,
espouse it.
As the appellant here, she has approached before the SP office and given some objection, and for that, I'm not getting a single penny. your
Those will
lordship.
be sorted out. But 5 lakhs is lower side. We are not even going to the marriage. We have not heard him. We do not know what will come from him. 5 lakhs. Today's context.
5 lakhs already she has withdrawn, your lordship. And if enhancement, at least your lordship, 1.5 to 2 lakhs, this would be his maximum capacity, your lordship.
18 lakhs is. How much pension do you get?
I'm not getting single penny, your
What
lordship.
is the rate?
Your lordship, around 22, I think 20,000.
Lordship, will find his last salary he has drawn
That was during my service, your lordship.
66,665.
Well, how much will be the pension?
And on 4th of March, he has received an amount of 35,000. I suppose that will be, I suppose.
No, there were some other benefits, your lordship, not that pension. My last pension was rupees, I think, 65,417, your lordship. And he has taken, your lordship, caretaker nurses, as he's totally bedridden, your lordship.
Mr. Paul, that's why I have asked you, how much is your medical expense? You said 20,000.
More than 20,000 actually, your lordship.
Now it has become more than
Including
20,000.
nurses and all other expenses,
Now
your
it
lordship.
become more than that.
Caretaker.
After a while, it will be again more.
Yes, your
Will not go by your word. What have you stated? What was the evidence before the learned court regarding your expenses? Did you take voluntary retirement?
No, your lordship.
Then how did you discharge your service?
Pardon, your lordship.
How did you discharge your service in the police? When did you suffer this ailment?
In Noga only, your lordship.
When?
Since 96 to 97. your
Thereafter, how did you serve?
At that time, I was not paralyzed, your lordship. I was gradually I got paralyzed. Your lordship.
When was it done? When was
It
it?
was done, I think, in 2016, your lordship.
You retired when?
This year, your lord.
From 16 to 24, what did you do? How did you serve?
Actually, I was given some help from that police that I was going to office and doing some official work, your lordship.
Not acceptable, not believable. Your excuses. You may be having some ailment, but that will not come in the way for giving permanent alimony.
Yes, also, your lordship, medical certificates were exhibited, your lordship, that are in the LCR, your lord.
We do not even know what are the ailments suffering by the wife. She'll have hundreds of other ailments. But that is not coming in the way. It's a matter of permanent alimony. Be reasonable. Don't say 1.5 lakhs, 1 lakh.
No, this is for enhancement, your lordship.
That is it, enhancement. We know 5 lakhs has been paid. You have said 3 times that 5 lakhs have been paid.
Yes.
We are not hard of hearing. Don't need of repeating. 5 lakhs is nothing. Tell us.
Your lordship, then I'll have to take instruction.
No instructions. We're going to pass an order. This matter is for hearing. We're giving you an option. You suggest whatever is reasonable from your part, but be reasonable. Not 1.5 lakhs.
2 lakh. I'll not, your lordship, I'm not bargaining, your lordship. 3 lakhs, your lordship. At best, that would be possible for him, your
You
lordship.
hear this matter.
Lordship,
Yes.
then
No.
appellant before lordship has got married on 26 to 1993, and after 1 year,
20
26 to 1993.
marriage.
Yes, marriage was solemn-
Parties are Hindus.
sorry,
Yes,
lordship, Hindus.
Okay.
Marriage was social marriage was solemnized.
Hmm.
Yes.
Okay.
And after 1 year of marriage, one girl daughter has
You have your seat, Mr. Paul. We'll come.
one girl daughter has born,
Yes. When was
and lordship,
what date?
exact date I don't know.
94.
No, on she is
94.
is it about 29 years?
So around 94.
Yes.
Daughter born. Okay. You'll have this in the your written statement. Where is your written statement?
Lordship will find my written statement at page 16.
Yes. None of you have even given the date of birth of your daughter. What kind of parents are you?
So,
Neither in the plain nor in the written statement. You have not stated anything about your daughter, Mr. Krishna.
in my assessment liabilities, I have stated the age.
That's a later part.
Yes, that's the letter.
He have not even mentioned about your daughter. He at least has said 1 year after the marriage, the daughter was born, female child was born. Okay, then what happened?
Yes, thereafter, lordship, on 26/1/1998, the respondent herein has thrown out of his house. The appellant has been thrown out from his house, and thereafter the appellant was staying in a rented house. Later on, she get accommodation in one of his through one of his brother and in a nearby place of his house.
Hmm.
Thereafter, the
Yes.
Thereafter, the appellant has filed one petition under 125 that was allowed, and 2,000 each, a maintenance of amounting to 2,000 each was granted to the minor child as well as to the wife.
Yes.
Thereafter, in the year
When was this? 125 petition disposal was which year?
it was disposed of on nothing was stated in the plain time written statement. Was
Which year? 125 was instituted which year?
1998 your lordship.
No, 1998 তো institute হয়েছিল।
16.
In the year 2016, one enhancement petition has been filed,
Okay.
and whereby the learned court below has enhanced the amount, and against that they had approached the filed a revision petition and which was rejected. Thereafter, they had also approached this honorable High Court.
No, no,
And-
you're wrong. Your enhancement was rejected
Yes,
initially.
sorry, Lordship.
District judge, session
Yes.
judge has enhanced.
Yes.
3,500.
Yes,
You're not equipped with the facts. Why? It's your case, not our case.
Yes, Lordship.
Why aren't you equipped with the facts? What is so difficult? You don't know when your daughter was born. You're appearing before us. Neither of you. What is this kind of assistance? Some year she was born. It seems she is not important to either of you. You don't know when the maintenance was filed. Stating wrong facts. Don't come just like this. Come for assisting the court or don't come. Yes, what happened thereafter? Yes, go on.
Yes, yes.
We'll see the facts. Whatever you want to submit,
Yes,
submit.
In the year Lordship 2019, the respondent has filed a divorce petition under before the learned Principal Judge Family Court at Nalbari, and thereafter the appellant has appeared and filed her written statement. And after that, due to COVID, both parties remain absent. Lordship may peruse the page 24 onwards. The orders passed by the learned court below.
Yes.
Yes, so on 27/5, due to COVID, case was adjourned. The case was fixed on 15/6. On 15/6, both parties are absent without steps. Thereafter, case was fixed on 13/7. 13/7 also, none of the parties remain present. Fixing case on 6/8/20. 6/8/2020, both parties, none of the parties were present. On next was fixed on 1/9/20. On 1/9/20 also, none of the parties present. Fixing 25/9, none of the parties are present. Fixing 20/10/2020.
Tell us what happened after all.
Yes, on 1/12/2020, Lordship, the order was passed and the case was fixed for judgment without giving an opportunity to cross-examine, whereby it has been stated that may I read the order, Lordship? The petitioner so-and-so is present with another witness, namely so-and-so, on the prayer of
Page,
respondent.
which is the page?
Is 26, Lordship.
Yes.
On the prayer of respondent so-and-so for cross-examination. The respondent has remained absent without any steps and as such forfeit her right to cross-examine these witnesses. Therefore, the case is heard. In the absence of the respondent, the judgment will be passed on merit since issues have already been framed, fixing one for judgment. And the previous date, Lordship, that is on 20/10/2020, on that day also both parties were absent without step. None of the parties were present. And on the very next day, on 2/1/2021, judgment has been delivered, Lordship. May I read the judgment, Lord?
Now, Mr. Krishnatra, this would be relevant if you are contesting the divorce aspect.
Yes.
You have said that you are not too much
Yes. Yes,
aggrieved
yes,
by the
yes.
aspect, or not aggrieved, you are not too much against the idea of living separately.
Yes,
By
because
you are only on the aspect
Yes.
of alimony.
Yes, sir.
So you can avoid those parts, because if we go on to those parts and
Yes,
set
yes.
aside this, nothing will be
Sure.
okay.
Then Lordship, Lordship will kindly peruse page 32
Yes.
of the judgment, Lordship. Last paragraph, Lordship. The petitioner admitted being still in the service as constable in his petition as well as in his affidavit, Lordship.
Page
Page
32.
32, Lord.
Which part?
Last paragraph.
Hmm.
That's what you find it.
Yes, yes.
The petitioner admitted being still in the service as constable. Admittedly, he is a government servant.
Hmm.
Then, Lordship, in the very next page 33, the
Please read the entire. He
yes, sorry.
said something about
Yes.
paralytic stroke also.
Yes. The petitioner admitted being still in the service as constable in his petition as well as in his affidavit. It has come up in the evidence of the petitioner above that he has suffered from paralytic stroke and has a regular expenditure to incur on his medical treatment. Apart from the expenditure on his medical treatment, he has no dependents to look after back home. On the other hand, respondent is solely dependent on the rupees 3,500 that she has been receiving in maintenance allowance and sustaining on the said sum. Now coming to the income of the petitioner to ascertain the amount of permanent alimony to be paid to the respondent, the court is inclined to consider the current salary of the petitioner. It is important to say the petitioner has not disclosed his current salary in his petition for divorce, or for that matter, in his affidavit in evidence. The court is inclined to take judicial notice of the same from the certified copies of the judgment delivered by the Session Judge Nalbari in criminal case number so and so against order of the SDJM Nalbari case number so and so, wherein the court has held the salary to be above 30,000 in the year 2016. Thus, with all revision in pay and increments, this court is inclined to accept the salary of the petitioner to be more than 30,000. Apart from the medical expenses of the petitioner and expenses he has to incur on his person, has not referred to any other expenditure or, for that matter, liability he has to discharge from his salary. Thus, considering the length of service the petitioner has put in till now, and apart from rupees 3,500 and his medical expenditure he has to incur, it is likely the petitioner must have sufficient savings during this period. Thus, the court deems it appropriate to allow a sum of rupees 5 lakhs in permanent limit to the respondent. Accordingly, the petitioner is likely to pay 5 lakhs to the respondent. The petitioner is to pay the same within a period of 3 months in installments or in full. Following the commencement of the payment of permanent limit, the question of respondent receiving monthly maintenance allowance in 125 proceeding will not arise. The parties will be so and so. Being every lawsuit, the appellant has preferred this appeal because she came to know only after the judgment was pronounced, when she got a notice from the court to that he was informed that the case was disposed of. Subsequently, he had appeared and she obtained a certificate and filed this appeal before the Honorable
This
Court.
judgment was ex parte.
Not ex parte, Lordship. Judgment she appeared, filed WS, but
No, the pronouncement was
Yes, yes.
in not in her presence.
no, Lord.
She had initially contested, filed WS, but
Yes.
thereafter
But
she had
due
not.
to COVID, both parties remain
Yes.
absent. which is apparent from the order dated.
Yes, we have seen
Yes,
the
sir.
earlier order.
Yes, sir.
Mm.
Thereafter, after filing this appeal, this court has asked both the parties to appear for the mediation. However, the mediation got failed. And subsequently, again, this honorable court has asked to submit the
Asset liability.
assets and liabilities as per Rajneesh versus Neha. Wherein lordship, in the assets and liabilities, the appellant has categorically stated at page 40, lordship will find at page 40.
40.
Yes, lordship. Details on income of the deponent. Heading F. Where she has in point number 3, yes, she has categorically stated her monthly income is 5,000 to 6,000 per month.
This is your affidavit.
Yes, lordship. Filed by me, the appellant.
Yes.
Thereafter, she has also stated about her expenditure and liabilities in this affidavit, lordship. Therefore, I will like to take your lordship to the bank statement starting from page 49.
Yes.
Whereby at page 50, lordship will find that the respondent before the judgment passed by the learned court below, the respondent was paying the monthly maintenance, and apart from the monthly maintenance amounting 7,000, the petitioner is not receiving any amount in her account.
Which page are you
The
referring?
page 50 onwards, the
Yes.
bank statement, the
Yes.
last 3 years bank statement,
Hmm.
and except the interest part and the maintenance given by the husband, he has received nothing. And lordship, at page 53,
Five three.
yes, lordship.
Yes.
Yes, page 53, lordship, in the second portion, that bank statement dated 4/5/2022.
Yes.
Yes, lordship, where the 5 lakhs has been credited to the bank account of the
Hmm.
appellant, and thereafter to have her livelihood, she have to withdraw the amount. Yes, sir. Now, thereafter, coming to the assets and liabilities filed by the respondent, lordship.
Page.
Page 57 onwards, lordship. Lordship, I will like to take your lordship to page 65. Lordship. Heading J.
It starts
Have
at page.
Page 65, lordship. Starts at page 57.
50.
7.
Yes.
Page
The affidavit of the respondent.
respondent, lordship. At page
Just
65.
just a minute. Just a minute. Just a minute. May 2024, 57. Yes, what is there? Page 60, 50,
Lordship, before the lordship, page 62 for a moment. Lordship. Page
62.
62.
Yes,
Heading F.
yes, details of income.
Yes, lordship. In Point number 4, as per Rajnesh Neha, if engaged in government service, furnish latest salary certificates or current slips or proof of deposit in a bank. This column has been remained blank in my copy. I don't know the copy. And page 65.
Here, nothing has been given.
Yes, Lordship.
62. Yes, no disclosure.
Yes, your lordship. Actually, what has happened, we
You'll
inspected.
be
the-
hauled for contempt. You'll be hauled for contempt. You be prepared to answer this. Yes,
Lordship,
prepared for answer this. Why have you not filled up 4?
Lordship, thereafter page 65. Heading J, Lord.
Civil 4. Not answered. 65.
Yes, Lord. Heading J, Lordship.
Just a minute. Nobody gave us a whether access to income tax. No, return to file koribo lagibo. No. Why not access to income tax? You have to look one how much income tax are you paying? He may not be paying any tax. Return over for 0. But he has to be assessed under the income tax. Nobody can go for it. 62. How have you said you are not assessed to income tax? 62. Point number 7. You're a salaried employee. You have to file returns. Mandatory. You may not fall into the slab to pay income tax. That's a different matter. But how are you not assessed to income tax?
Those were deducted from my, yes, your lordship. That-
Whether it's TDS or whatever, you are assessed to income tax. How you said no? Yes, next.
Page 65, heading J.
J.
Whereby in point 1, HSLC pass, yes, Lordship, true. Point number 2, Taylor, yes, Lordship. And in point number 4, particulars of the assessment levels of the spouse as known to the deponent along with any supporting documents. The respondent has stated that 20,000 per month, but there is no any supporting document, Lord.
Okay.
Yes, Lordship. Then I would like to take your Lordship to page 76. Whereby the respondent has
Now, how much he has stated to be his income?
Lordship, in his assessment liabilities, as per bank statement, I have got the amount, but in his assessment liabilities, I could not find, Lordship. I suppose.
Pension revenue not received yet. Not given. Ekhone post statement now. Page 62. Where is Rajesh Neha? Where have you got Rajesh Neha?
No, Lordship. I have the citation otherwise, Lord.
এখন আনে।
This 2021 to SSC, Lordship.
Live এখন live। হেল্প কৰি দিয়ে না এই ৰাজেশ নেহাটো ওলাই দিব দিয়ে
2021 to SSC, page 324.
Madam Jahan, can you help us? We need the citation. You can give it to our or transmit in the WhatsApp. We'll get a print. That Rajesh versus Neha.
Rajesh Neha, Lordship,
Yes, that. Now we will take a print. Can you just feed it? Yes, that is it.
I don't- Oh, sorry, sorry.
That's
No, no, 2021, 2 SSC, 324. I went to take
324
print out, but the library
2021
it was with me.
order to doesn't.
No, we'll take a print, that's not a wish. পাৰিব নহয় মেইল কৰি দিলে ফটো
I'm sending to me if you can take out.
তোৰ পৰা নাই ইয়াৰ পৰা এটা নাই নেকি কোনো আমাৰ আছে নাই ভিতৰৰ পৰা লৈ আনা ইনফেক্ট আমাক হেৰি দিয়াই আছে মই ছেপাৰেটলি আমাৰ এই যে ৰাইট চাইডে মই যে ৰাখো সুপ্ৰিম কোৰ্টৰ পৰা পঠোৱা সেইটো আছে গতিকে ওলাই লৈ আনা Yes, what have you
Yes, sir.
yes after 65 we have seen thereafter
Okay, page 76, Lord.
yes
On 19/4/2021, Lordship, the respondent has deposited a permanent in the Vipoda code, the learned code below. And Lordship, at page 78, Lordship, will find the order whereby on 19/4/2020, after 1 year of the deposit amount, Lordship, the appellant had to withdrawn the same for her livelihood, Lordship. Now, at page 79, Lordship will find one medical document of 6/5/2024, whereby some medicines has been recommended to the respondent, and one advice is rest for 2 weeks. Nowhere in the document is stated that he is paralyzed, he was paralyzed or something like that. Some blood test was also advised. And Lordship, at the very next page, page 80.
just a minute বুজি নাপাওঁ নহয় কি কৰিব Euro. এইটো কি হেৰি এইটো কি বিভাগ নিউৰোসাইকিয়াট্ৰিষ্ট নিউৰোসাইকিয়াট্ৰিষ্ট হয় ন নিউৰোটো জানো বুজি পাওঁ সাইকিয়াট্ৰিষ্ট হ'ব পাৰে yes page 80
Lordship, yes, page 80. Bank statement starts at page 80. Whereby the bank statement has been provided from 2nd of May 2023 till 14th of March 2024. Lordship will find his salary as on 2nd May, it was 63,058 rupees, and in the same month, again from the treasury, he has issued an amount of 3,296. And Lordship, there is in the debit column on 3rd of May, there is a debit of rupees 2,161, which was debit CMP mandate debit TVS credit service. As per my information, there is a EF, I am not sure, but as per my information that one scooty has been purchased by him, for which he is paying a loan on upon rupees 2,161.
okay
So I don't know if he is paralyzed, how can he ride a scooty also? And Lordship, at after his salaries you will find a lordship, 1st of June 2023. Then on page 81, 1st of July and 2nd of August. And last lordship at page 84. On 3rd of February, he has received 66,665 in the 6th row. And lordship, as per my limited understanding, lordship, the bank statement is to be submitted for last 3 years. And lordship, the lordship, during pendency of this appeal, lordship, the appellant has filed one RTI application asking for the record of the service book, and she got a reply from the office, whereby along with the one and enclosure of kinder roll, wherein it is shown that some Ruma Ranu Roy name has been recorded in his service roll as per his wife. And in the second page, lordship, you will find then one son name has also been recorded as Akash Roy, whose date of birth is in the year 2000. So, lordship, my respectful submission before this honorable court will be, lordship, the alimony granted by the learned court below is to be enhanced, considering the all entire facts of the matter. And during mediation, he has stated that he will bear all the expenses of his daughter's marriage. And in that assurance, lordship, he has the appellant has taken some loan also, but while the daughter called him over phone to invite and to ask, then he reluctantly refused to attend his daughter's call, and he has not paid a single penny till date. And the appellant has a huge loan as on date. So my respectful submission before this honorable court be amount may be enhanced to rupees 80 lakhs as claimed by the appellant. And
When did he retire?
on February
2024.
on last day of February 2024. And after filing of this appeal, maintenance was not paid since he already deposited the permanent alimony. For her livelihood only, she had to withdraw the amount. And from the bank statements, it is clear that she has left with no money.
ইমান লম্বা নেকি নে কি? ৰাষ্ট্ৰৰ খিনি উলিয়ালে হ'লে হয়, এনেকে আৰু তো বুজি চুজি নাপায় যে গাইডলাইনছ খিনি উলিয়ালে হৈ গ'লহেঁতেন। ডাঙৰ নালাগে ন গোটেইখিনি, গাইডলাইনছ খিনি ওলালে হৈ গ'ল। বন্ধ কৰক, পেজবিলাক ৱেষ্ট কৰি আছে মিছামিছি, নকৰিব।
এটা becomes 6 pages.
Not required, we know, just need the guidelines, this will understand just wastage of
Guidelines,
pages,
Last pages
last pages,
could have said
বন্ধ
that.
কৰক এইটো।
In fact, after this judgment, many lower courts have not followed. And the matter reached the Supreme Court. Supreme Court said that High Court circulated judgment against them on.
No, there was a circulation, we remember. That is why we'll ask Mr. Paul, he has not even disclosed. 3.2,
The High Court will remand it back to lower court to take into consideration. That is also.
66. 7. 4th March. 24. 84 days of 84. Before. Entry to 3rd February and 3rd February. It whole salary last salary was 66. পাইছে না 3rd February, তাৰপিছত আপোনাৰ 4th March also. 4th March চলো 4th March 35 it was pension of আপনি কি পাই pension pension দিলে বন্ধ করা আছে কমপ্লেইন তো
This 57 ৰ পৰা দিলে।
দুদিন বন্ধ করা কি আমি করব ঠিক না নাজানো আমি কমপ্লেইন তাৰপিছত বোলে কৈছে ৰিকুৱেষ্ট কৰি বন্ধ কৰা এইটো মাৰ্চ 2024 তাৰপিছত আমি যে দিয়া নাই কেনেকে আমাক জনাইছে এফিডেভিট দিছে আমি দিলে যে কিহৰ কাৰণে দিলে এইখিনি কিহৰ কাৰণে দিলে না আমি মেঘালয়ৰ কেছ চাই আছো কি কি কাৰণে দিলে কি চাই পেলাই দিয়ে দুখন অলপ চাব না এইটো এফিডেভিট ফৰ ষ্টেট অফ মেঘালয় আমাৰ নহয় এইটো অলপ মাইণ্ডটো এপ্লাই কৰক ন যি কওঁ সেইটো ক'লেতো নহ'ব চাই লওক ক'ত অসমৰ বিষয়ে আছে সেইকেইটা পেজ দি দিয়ক
No, please, Lord, I have those deadlines of ethnic and I have
when was
from
the
another
judgment of
judgment.
the Neha passed date of the judgment
This is
Lordship,
November 2020.
please get us the date
After- Long judgment.
come to the first page
Yes. 4th November. 4th November 2020.
দুটা বস্তু ৰিমাণ্ড কৰা কোনো হেৰি নহ'ব এপ্ৰিলত সেই সময়ত বাৰু জানুৱাৰী 2021 জাজমেণ্ট আছিলে
নেহা ওলাই গৈছিলে কিন্তু নেহাৰ বস্তুটো নাজানিব পাৰে কিয়নো এজন এপিলেট কোৰ্ট আমি তেওঁলোকৰ পৰা বিচাৰিছো সেইটো দিছে ইয়াতে সেই বেচিছত আমি ডিচাইড কৰিম আৰু এওঁ ষ্টেটমেণ্টটো ক্লিয়াৰো হোৱা নাই
Yes, Mr. Paul.
Thank you, Lord. Lordship, regarding that, of page number 62,
You,
details of the income of the,
yes, you narrate the facts. Whatever you want to state, you come to 62
regarding
one by
that
one. You
document of
whatever you want to say, you say in serially.
regarding that, your Lordship, submission of salary certificate and pay slips, your Lordship. Actually, he was not in a position to give us, your Lordship, so we could not annex those parts. And if your Lordship allows, your Lordship, we will file fresh asset and liabilities, your Lordship.
It's been done already. There's no provision for submitting two statement.
I think there is provision, your Lordship, as per Neha versus Rajneesh, that if there is some changes in the circumstances of the parties, your Lordship, then they can submit, your Lordship.
Where is the change in circumstance?
After retirement, your Lordship,
This you have given after retirement, he has put on record,
and
you are getting 35,475 as pension. Come to page 84.
yes, your Lord. That was not of pensionary benefit, your Lordship, 35,400.
What is this then?
Some other benefits, your Lordship, not from pension, as he has not received till date.
Where have you stated that they have not received pension?
Your Lordship, at page number 62, F, point number 3, your Lordship, monthly income pensionary benefit not received yet. Your
And where is the statement? What is this amount? On 4th of March? And that too by Nagaon Treasury? It is an official payment. There is no credit from any other source. Your last salary of 66,665, 3rd of February 2024 at page 84. Thereafter, the next credit is 35,475 from Nagaon Treasury.
Yes, your Lordship, but when we submitted this bank statement, your Lordship, thereafter, as per instructions.
This you have not given. This is not your affidavit. This is their affidavit, I think.
No, your Lordship, this is our affidavit
Your affidavit.
from page number 57.
Okay. So this statement you have already given as it covering as late as 14th of March. The other amounts here, 35,000, it commensurates with your salary. Contour. No, itu suatu na itu.
Your all pensionary benefits, why it has been stopped?
Your Lordship, the appellant, she has approached before the SP office and submitted application not to give pension, your Lordship, stating that the appeal is pending before this honorable court. So petitioner, respondent husband, your Lordship.
Then
he
was there any order from this court?
No, your Lordship. Thereafter, once, your Lordship, I have also contacted with the officials of SP office, your Lordship, but they told that as the application is there, that the case is pending before this honorable court, so they cannot dispense that amount, your Lordship.
Where have you stated those? Where have you stated those?
No, your lordship, actually those were verbal communication. Your
No, where have you stated in the affidavit? It may be verbal communication. See, you have filed this affidavit as late as in 16th of May 2024.
Yes.
16th of May 2024, you had retired when?
February-
Retired in February 2024. March, April, May, after 3 months, salary, your pension has been stopped. It has been stopped as per you is on a complaint. Where is the statement? It may be a matter of fact that it has been stopped. Where is the statement?
I have not stated, your lordship, just stated that pensionary benefit not restricted.
Hmm? এখন ফাইল করছে কেতিয়া এখন মেড ফাইল করছে ফুল নাম মেড কিবা আমাদের রেডিও হয়েছে তো মেড ফাইল করেছিল না মার্চের লেগে স্টেটমেন্ট দিছিল Mr. Paul, your statement is up to March. You have filed this on May 16th of May. Why till March?
Yes, your lordship, as because the deponent, husband, your lordship, he could not communicate us with the documents, your lordship. So as last chance was given, so we have filed this affidavit, your lordship, with some minor documents not being annexed, your lordship. With some documents. So I may be allowed to file.
That is a part of the asset liability statement. Your statement affidavit is filed in May
Yes, your lordship.
with a state bank statement of March. Why?
Your lordship, I may be given some time so that I can submit the bank statement at least, your lordship. Up to date.
Even if you assume that whatever you stated is correct, that there is some complaint. First, there is no restriction by any court of law. There cannot be any embargo in releasing the pension. But even if you assume that it's been stopped for the time being, after disposal of this case, there will be no such impediment. We'll make it clear.
So, your lordship,
We
I
are
may be allowed-
deciding on the alimony part. Both of you have agreed that you are not too much in variance with the aspect of divorce. It's only the question of alimony. You not paid any money during your daughter's marriage.
Yes, I don't have that instruction, your lord.
There is no debit. There is no debit shown.
Yes, your lordship, from bank account.
There is no debit shown.
But as per my knowledge, your lordship, when they were in the mediation center, at that time, the husband, your lordship, he offered, I think, 1.5 lakh. I think that is in the mediation report, your lordship.
We are not on the enhancement part.
And during and for that daughter's marriage, your lordship, the husband, he told that as she is also my daughter, so I will bear all the expenses for her marriage. But there was a small condition, your lordship, that the daughter's marriage should be from his house, your lordship. He had that small request to his wife, your lordship, but they denied that. So there are some complications. And,
That's not connected with the marriage, with the expenses of the marriage.
regarding that monetary help, your lordship, I don't have any.
Your salary clearly appears to be, last salary was 66,665.
Yes, sir.
That was in February, 3rd of February, credited to your account.
Thereafter, we also see an amount of 35,475 on 4th of March. This obviously have to be either pension or some post-retirement benefits.
Yes,
It's
sir.
come from the government treasury. Thereafter, you have not even given anything. 5 lakhs is otherwise also too less an amount.
Some amount may be enhanced, your lordship. It's 3 lakhs.
People. Nominal. Okay. ইমান দিন চাকৰি কৰিলে না পোষ্ট ৰিটায়াৰ বেনিফিট পাব গ্ৰেচুইটি পাব চব পাব 5 লাখ অলৰেডি দিছে পঢ়াবতো লাগিব পঢ়ালে হয়তো কেনেকে হ'ব এটা জীৱন বৰ What is your age?
My
Age, yes.
my age is lordship 52. 51 when I file affidavit, as on date 52.
চিলাই বিলাই কৰি চলি আছে দিয়া দিলে মানে এনেকুৱা নহয় চিভিয়াৰ হৈ গ'ল ৰিলেশ্যন বিহেভটো মোৰ বাপেকে যে জীয়েকৰ বিয়াত নগ'লে এপ্লিকেশ্যন নিদিলে এইটোত বাহিৰে একো নিদিওঁ পইচা দিলেও একো নকৰিব নিদিলেতো নকৰে দিলেতো এটলিষ্ট ফাইনেন্সিয়েল কিবা এটা বেনিফিট হেৰি কৰিছোঁ ক্ল'জ কৰিছোঁ মই 5টা কৰা হ'ব 18 লাখ কৰিছোঁ কিন্তু আজিকালি দিনত 1 কোটি টকাও দি আছে কোৰ্টে মই এণ্ডৰ্ছ কৰা নাই কেতিয়াও ঠিক নহয় কিন্তু এনেকুৱা নহয় যে আৰু কিছুমান ক্ষেত্ৰত কি হয় ইনকামটো আমি নাজানো ইয়াতেতো ইনকামটোতো ইজ বিফৰ আছে ডেট ইজ দি নন চ'ৰ্চ অফ ইনকাম আৰু বেলেগ থাকিব পাৰে ৰেণ্টেল থাকিব পাৰে কিবা থাকিব পাৰে আৰু তেওঁ ক্লিয়াৰো কৰা নাই যে তেওঁ বেলেগ বেলেগ মাৰ্কেটত থ'বলৈ কিবা বহুত এইটো যোনখন দিছে আপোনাৰ এক 2031 দিব সেইকাৰণে এইটো কথা একদম নহ'লে বেলেগে ক'লে মোক সন্দেহ কৰিব লাগে You have another wife and a son.
Actually, I really don't have that instruction, but I asked my husband, I asked the husband, your lordship. He told that he's a caretaker, your lordship.
And Akash Roy is your son.
I don't know, your lord.
No, in the service book, it's been reflected. He was born on 2000. You got divorced in 2021. Immediately after driving off your wife, you marry somebody else. And now you cannot also officially disclose. It's an offense. Here is up. Left of the sub. Here is nominated in case of that. Kumar Roy, my phone, is sent to constable, body number. Here to farm person.
Mr. Paul, anything else? Brother, you have not said anything. What are your submissions?
It is only your lordship that at least 3 lakh rupees may be enhanced your lordship, or else won't be possible for the husband your lordship.
On marriage, what do you say?
I don't have that instruction your lordship.
No, you are contesting a matter.
On day.
It's not a matter of instructions now. Is
Regarding that-
anything else?
No, your lordship, regarding that marriage, your lordship, yes, I was also not aware that. That's right. They have never stated that in the learned family code also, your lordship, that either he is married or not. I have also come to know just now that.
You stay at Nagaon
Yes, sir.
and you are at Nalbari.
Mhm.
Please considering my health condition, your lordship, and future expenses.
What's your health condition except for the prescription? Have you?
Yes, your lordship, not here, your lordship, that is in the LCR, your lordship,
Yes, which one?
at your lordship, file C1, page number 10, your lordship. And file C2, all the medical documents, your lordship.
C1, which one? Page number
Page
10.
number 10, your lordship, onwards. There is also a medical certificate, your lordship, that he is suffering from paralysis. And at file C.
Who has proved this? Medical certificate? Yourself.
No, your- And at file C2, your lordship.
Who
All the-
exhibited all these documents before the trial court?
Yes, your lord.
Before the
Pardon?
Lanet trial court below, who exhibited all these medical
Yes,
documents?
sir.
By you only?
Yeah.
By
No.
you?
Yes, your lord.
No, it was not proved by the doctor. Doctor had come.
No, your lordship, doctor did not come. As the case was stopped during that cross-examination, your lordship, because of their absence. So further proceeding could not.
Doesn't matter, but you have said that exhibits so and so are medical certificates submitted by the deponent.
No, doctor did not prove there in the portal.
The question like if he is some, was under paralysis, suppose, how he can appear? If he is not in a position even to.
এখন দিছে ইয়াতে apply হেৰি কৰি। এখন কিন্তু
কি
form
আহিব পাইছে
আহিব।
নেকি তাৰ? কোনে exhibit কৰি দিব? কি আহিছে নেকি?
Did you present these documents
Yes, your lord.
before the court? You had come to the court.
Yes, your lord.
গন্ডগোলীয় document.
Hmm.
51 years লিখেছে এখন 2019 What is your retirement age? 58 or 60?
60, your lord.
60. In 19 we were only 51. If you go by the certificate, 2019, you're only 51 years of age.
I think some typing mistake was there.
Not typing mistake, handwritten. Who is this doctor? What is his name? You have not stated anything. Doctor has not come, that's a different aspect altogether. And prescriptions? What is this kind of prescription? And which is the other file? File C2?
C2, your lord.
Which page?
Starting from page number 5, your lord. Social democracy.
No. লাখ টকা ট্রেজারি চালান টু 19 কেনেকে দিলে বুজি পোৱা নাই 5 লাখ টকা ট্রেজারি চালান টু 19 কিয় দিলে judgment to 2/11/21 hai more mothe. What is the date of the judgment?
12/1/20, your lord.
Huh?
Yes.
2/1/21.
21.
2/1/21. This treasury challan, why is it of 2019?
Pardon?
Treasury challan of 5 lakhs.
Yes.
500,000. No, I do. 19 March 2019. Sir. It was in order 19/4/2021. 19 March 2019. ঠিক আছে সেটা পাইছে ব্যাংকৰ ভুল নহয় Mumbai branches.
I have deposited that on 19/4/21, your lord.
19/4/21.
19/4/21.
এইটো বোধহয় 21 হ'ব লাগিছিল নেকি? কিবা এটা হ'ল চাগে।
Photo filter look, otherwise photos features.
মেডিচিন স্পেচিয়েলিষ্ট ডিফিকাল্টি আছে আমাৰ কিন্তু এনেকুৱাও ডিফিকাল্টি নহয় যে কৰিব পৰা নাই।
Physical difficulty আছে আকৌ financially আৰু এগৰাকী reputation
Horizontal drawing from right discovering. Diagnostic reports are clear. Hemoglobin 11. কি মানুহটোৰ নাম কি?
হেৰি কিবা গৌৰীকান্ত
গৌৰীকান্ত কি লেখে? এটা পুরো গৌরীকান্ত কিছু আছে এগুলো ঠিক আছে এটা তো গৌরীকান্ত রং না এটা হয় বলে ভাবিল এটা আছে নিশ্চিত Who is Runu Roy?
Runu Roy.
Your documents.
all these documents are for
It
Runu
is
Roy.
his second wife, I suppose.
That's
So you have given these documents. How will it come with the records?
That is helper, your lordship, caretaker, I think.
Why have you given her medical documents?
what to do with her documents.
Helper suffering from ailment, you will submit in the court. It's your documents,
Yes, sir, but I was not that counsel, your lord.
not a matter of you being the counsel. Consciously, he has given the documents of one Runu Roy, female. And Runu
You need to
Roy,
submit a
Runu
passport
Roy is in
document, that is-
Khottebari in Barpeta. You are at Nagaon. Khottebari, Barpeta.
Whatever it is. Give a diagnostics.
মানুষ জায়গা দিব লাগবে।
আপনি একটু বাদ
Okay, anything else?
Lordship,
Mr.
may I give it a little, if I leave, be allowed to reply, Lordship. Roshni peruse the order dated 13/10/2023 passed by this honorable court. 13/10/10/23. And Hyde order dated 13/3/23, both the parties has been directed to file the affidavit as per Rajneesh versus Neha.
13-3.
Sorry, 13/10, sorry, Lordship, 13/10/23.
Yes, correct.
13 on, and they have filed their affidavit only on after a lapse of more than 6 months. So the plea taken by them that they could not obtain the documents is not acceptable. Lordship. further, as per Rajnesh versus Neha, bank statement on 3 years is required to be filed, but they filed for 1 year to 2 months. And regarding lordship, my life friend submitted that the appellant has submitted one application before the authority to stop his pension, but the appellant has only submitted one RTI application. And after getting the RTI application, when the department came to know that the divorce is still pending before the Honorable Court, might be for that reason they have kept the whole, but I am not aware, but no complaint has been filed. And the statements made by my learned friend lordship regarding the marriage of his daughter, yes, it is true that he have made a condition that my daughter solemnization of their daughter is to be organized at Nogao, which is practically not possible because since 1998 the daughter, since her birth, she is at her native place at Nolbari, that is Tihu. And for that reason, he have stated that if the marriage was solemnized from Nogam, he will clear all the expenses. But since the marriage was from Nolbari, he have declined to pay a single penny also. That's my submission. And regarding quantum, I left to your lordship, considering all aspects. My prayer will be 18 lakhs only, but up to your lordship. Looking the age and the loan which is borne by the appellant for her daughter's marriage, lordship may consider the alimony, looking all the aspects of the matter.
My entire life, your lordship, I have paid maintenance to the appellant, your lordship.
What is the big deal you have done?
Yes,
Paying 3,500 to your wife and 3,500 to your daughter.
so she was not
What
with
is the
me.
big deal you have done? Tell us.
So she was not
7,000 per month to your wife and daughter. And you are very proud that I have been giving 7,000 to my wife and daughter. You have married, you've done an offense in the year 2000. There was no valid divorce. You're lucky that they have not proceeded against you. You should be behind the bars. And you're bargaining for 5 lakhs rupees. Court has sent for mediation. You could have easily settled the matter. If not 18 lakhs, pay something reasonable. Now even you're saying 1 lakh 5,000, 50,000. Is it a reasonable stand? Your own volition, you had given medical documents of your second wife, even before the divorce had taken place. Even if we discard the service book excerpts, what about the medical documents? From where does this Runu Roy comes into being? Okay. Heard, so and so, so and so, so and so. Peruse the records in original. Hearing is concluded, judgment is reserved.
Deputy Lord.
नाम लिख लीजिए ना. পক্ষে লাগিব mandatory. Okay. What is this matrimonial appeal?
Lordship, it's the
You are for the respondent?
yes, Your Honor. The appellant is filed.
Yes, Mr. Bora?
Oh,
I'm for the appellant husband, your thoughts.
Hmm.
Lordship, the appeal is preferred against the judgment on decree dated 17/11/2021 passed by the learned principal just family court Kolkata, Your
Yes. You
Lordship.
were the first party.
Oh, yes, my lord.
You had prayed
He
for
was
divorce.
he was the plaintiff in that plaint, my
You
lord.
had prayed for divorce.
Yes,
It has been
divorce
declined.
under section 13(1) Roman 1A, lord. The cruelty, so far that was the ground taken.
Declined.
That was the,
So you are before us.
yes, my lord.
Okay.
Agree with that, my
Oh,
lord.
okay. Have your seat, please.
Yes, Your Honor. So far, the learned court below, my lord, observe that the finding of the learned court,
What are your grounds for seeking divorce?
the ground was the cruelty. It was so far the ground was taken, and so far the adultery was also there along with that. But the so far finding of the learned court below, the learned court below observed that the husband failed, the appellant failed to prove any
How many witnesses?
altogether, there are 3 witnesses in the prosecution side and 3 witnesses.
Along with you?
Yes, including me.
Plenty of witness. Okay.
Yes. And 3 DWs also. my lord.
Okay.
So for the question of cruelty, my lord, that issue, your lordship will find.
Let's see your plaint, your petition.
Plain, my lord.
Yes.
Lordship will find that page 16 annexure B.
Annexure
Annexure B.
B.
B, my Right. Page 16.
Yes.
My lord, right. And so far, the judgment is, may I point out regarding the issue, my lord, because the cruelty that was taken into consideration, the issue number 3, my lord, what
Mm.
it will find, it is discussed by the learned court below at para 10,
Page.
page 33. Whether the defendant treated the plaintiff with cruelty in course of their marital life. Page 33. So number 3. May I read my? So far, he has also placed reliance on the Supreme Court judgment, Honorable Supreme Court judgment, my lord.
Please, whether
Whether cruelty,
the defendant
defendant
treated the
treated the
plaintiff
plaintiff with cruelty in course of their matrimonial life. and whether the defendant deserted the plaintiff. So far, the desertion that ground was not taken, the plaintiff. So number 3, please 33 might therapy in the judgment.
33, okay.
33 in the
Yes.
judgment.
Yes,
Therapy.
yes.
This is the most important and vital issue of the case. To prove cruelty of the defendant, the plaintiff has PW1 adduced evidence that the marriage between him and the defendant was solemnized on 27/9/12. As per social rights and customs, and after the marriage, he started to live with the defendant as husband and wife in his own house. He stated that after 1 month of their marriage, the defendant started creating trouble with his mother and other family members, as he had no intention to live in a joint family. The defendant never respect his family members and abuses them using filthy language. She used to go to her parents' home without intimating his family members. And after staying few days there, she come back to his house. PW1 stated that he is a grade 4 employee at Borpeta Development Block, Kempusi branch. He used to go to his duty at 9:30 PM and return to his house at 8 PM. In the absence of that, absence at home, the defendant goes out of the house and she doesn't listen to his any word. About 5 months back, one day at around 30 PM, he suddenly came to his house and saw the defendant was talking with one unknown boy in their drawing room in an objectionable mode. While he asked the defendant about the boy, she replied that the boy is the brother of the friend. Thereafter also he came to know that the defendant frequently met the said boy at different places. She used to go to Guwahati by telling him falsely that she would go to her parental house, but she met the said boy in Guwahati. PW1 further stated that on 24/8/2017, my lord, at around 11 AM, taking advantage of no family members at home, the defendant left his house taking ornaments, clothes, and cash 10,000 with her. On next day, he came to know that defendant had gone in a white Indica car. He immediately ran her, but she didn't receive his calls. After a few days, the defendant called him and expressed her willingness to divorce him. He stated that the defendant has destroyed the matrimonial tie with him. The behavior of the defendant is rough and cruel, and she doesn't know how to lead a peaceful conjugal life. Therefore, it is not possible on the part of him to continue conjugal life with the defendant. PW2, Manjit Das, brother of the plaintiff, and PW3, Robendra Das, also deposed supporting the evidence of PW1 that since after the marriage, the defendant stated to misbehave with the plaintiff and his family members. And one day, taking advantage of no family members at home, she left the house of the plaintiff. The defendant, by examining herself as DW1, deposed that she lived in the house of her husband peacefully for about 3 months, but thereafter the plaintiff started to insult her and torture her physically. That the street on articles given at the time of her marriage are standard of demand of rupees plus 50,000 from her parental home. The plaintiff also asked her to take back the street on articles and provide him standard furniture. While she protested, the plaintiff subjected her to physical torture. She informed the matter to her parents, and they advised her to tolerate such torture for the sake of marital life, but torture on her didn't stop, and so father paid rupees so and so on 27/1/2013. Thereafter, also the plaintiff again stated torture on her of petty matters, and being no other alternative, her father paid rupees 80,000 to the plaintiff on 8/14. In spite of the torture on her continued, PW1 stated that on 24/8/17, the plaintiff assaulted her, and by catching, this is my lord, this is the on 24/8/17, this is the allegations of her from their side. The plaintiff assaulted her, and by catching hold of her, drove her out from her marital house, my lord. Finding no other way, she called her father, and her father took her to his house. Since then, she has been residing at her parental house, and the plaintiff neither inquired about her nor provided her any mandate. Hence, she prayed for justice. DW2 Prasad Bania, father of the defendant. DW3 Navokanta Bania lends support to the evidence the defendant that the plaintiff physically tortured the defendant in demand of the outcome. So far, that part is also appreciated by the trial court. The cruelty inflicted upon her, that was appreciated by the trial.
Where is the appreciation?
Lordship will find
The defendant destroyed the matrimony.
Lordship will find that
Also got the allegation.
page 38 also, I think
38.
38, the last para is discussed.
Yes.
The citation is there, according it is discussed also. The object of dissolving a marriage between the
Now,
parties.
these are citation. Where is the application of, on the facts?
And maybe otherwise, the period of time. Wait, wait. In the, so Lordship, page 36, the last para.
Yes.
In the instant case also discussed, it is seen that the plaintiff mainly brought the allegation that the attitude of the defendant towards her husband and other family members was never cordial, never obeyed and respected plaintiff, nor had any respect towards his aged parent. She was always rude and arrogant in nature, and her cruel behavior and attitude caused immense mental pressure to the plaintiff. On the other hand, the defendant as well as her supporting witness brought the allegation of torture on the defendant by the plaintiff. She stated in her evidence that the plaintiff insulted her and tortured her, that the Streeton articles given at the time of her marriage are of below standard, and he demanded rupees 2,50,000 from her parental home. Her father paid rupees so and so and thereafter 80,000 to the plaintiff. But on 24/8/17, the plaintiff assaulted her and catching hold of her hair, drove her out from the marital house. The plaintiff failed to describe any compelling situation which can be held as a grave and weighty to pass the decree of divorce on the ground of cruelty matter. The appreciation by the trial court on the cruelty being inflicted on her. It was appreciated, my lord. And so far the here in this judgment, in the next paragraph also, it is also only,
These are the contentions.
yes, my lord.
If you read the starting of the paragraph at page 36, last paragraph. Is
Oh.
in the instant case also as discussed above, it is seen that the plaintiff has brought the allegation. These are all your contentions.
Yes, my lord.
Where are the findings that yes, we accept that there were cruelty?
Different.
The reason to equal
Plain- I- for the education of The trial court also I observed that she was compelled to leave the house of the appellant minor because of that rule. So even after discussion of the judgment, the trial court observed. So the trial court appreciated their evidence. But so far the evidence part is concerned.
No, it is not their case that they have come up for cruelty. You had come up for.
I had come up for cruelty, but that was appreciated by the trial court on the basis of that.
She is not seeking divorce.
On the basis of that, the trial court observed that
See, you have
she
to make
was,
out your case on your own.
yes, my lord.
You have taken the grounds of
She was
cruelty.
compelled to leave my house because of that cruelty. That means her cruelty was more appreciated by the trial court.
Mr. Bora, you cannot, standing there on this side, you cannot make out that her allegation of cruelty has been appreciated. She never came to the court for a divorce. She is only explaining why she is living separately.
So far the trial
See, you
court,
have made out an allegation of
Yes, my
cruelty and
lord.
desertion.
the
You
tri-
try to prove your case, and if you have proved by cogent materials and those have not been
Yes, the
appreciated, then you
trial-
make out a case.
That's fine. The trial court held that I could not prove it grave and weighty matter. So, my lord, the deliberate course of conduct to hurt and humiliate the appellant, my lord, that also amounts to cruelty. The Honorable Supreme Court judgment is
Yes, where?
judgment. No.
Citation, please.
At citation lordship, Sujata Uday Patil, my lord, 2006-13 Supreme Court 272, my lord. To Sujata Uday Patil versus Uday Madhukar Patil. 2006-13 SCC, my lord, 272.
Paragraph?
Para 7, my lord. Para 7, my lord. It's 70. The word cruelty and the kind of degree of cruelty necessary which may amount to matrimonial of has not been defined in the act. What is the cruel treatment is to a large extent a question of fact or a mixed question of law and fact, and not dogmatic answer can be given to the variety of problems that arise before the court in these kinds of cases. The law has no standard by which to measure the nature and degree of cruel treatment that may by the test. It may consist of a display of temperament, emotion, or perversion, whereby one gives vent to his or her feeling without intending to injure the other. It need not consist of direct action against the other, but may be misconduct indirectly affecting the other spouse, even though it is aimed at the spouse. It is necessary to pay all the accident and quarrel between the parties in view of the impact of the personality and conduct on the spouse upon the mind of the other. Cruelty may be inferred from the facts and matrimonial relations of the parties and interaction in their daily life disclosed by the evidence. Said point can only be drawn after all the facts have been taken into account. Where there is proof of deliberate force of conduct on the part of one and intended to hurt and humiliate the other spouse, and such a conduct is persisted, cruelty can easily be inferred.
Your evidence is utterly lacking, Mr. Bora.
My lord.
Paragraph 5 and 6.
5 and 6.
You have just duplicated the pleadings. Copy and paste.
5 and 6.
একোৱে পোৱা নাই সকলো দিনা আহিলে কোনোবা লগত কথা পতাই দিছিলে তাৰ আগতে এইটো পেৰেগ্ৰাফত কৈছে ব্যৱহাৰ কৰে মাকৰ লগত একদম সকলো এইখিনি জেগাত কুইলিটি কেনেকে হ'ব সেইটোতো বাৰু হেৰিয়ে নকৰিলো সেইটো বাৰু নেও বৰ্ণন কৰিছে এইটো
Is there no dispute with the proposition? It's a misquestion of facts and law.
Yes,
And many things may amount to cruelty, but you have to plead. You have to adduce evidence. Where are the evidence?
Yes, my lord, regarding the entire incident that started from the date 24/8/2017. The allegation of the appellant was that she has left his house, matrimonial house, without his knowledge and consent,
No, see,
taking away the
trying,
ornaments.
you are trying to make out a case of cruelty, that she had inflicted cruelty upon you.
Yes, my lord.
Where are the supporting materials? What have you stated? Her leaving the house, that is one factual aspect.
So far, our evidence is concerned, evidence of PWs that could not be rebutted by them.
What is the evidence? Is it required to be rebutted? Read paragraph 5 and 6. You are abandoning the adultery part, so we are not going into that aspect
5 and 6 of my
of the evidence. PW1.
PW1 to yes. 5 and 6, my lord. The basic intention of the positive part. Lordship, the examination in chief.
Yes.
The basic intention of the opposite party was leave the matrimonial house, as the opposite party doesn't want to live in a joint family. The opposite party started to misbehave with my family members, use silly language and do not respect the elders. The opposite party used to live in parental home without the permission of either me or from my family members. The opposite party used to leave the matrimonial home and stay at her parental house, and again after
See,
remaining.
these are not consistent. She used to stay in a rental place, then her matrimonial place.
And thereafter, my lord, that
Two sentences are not matching.
used to leave the matrimonial house, stayed at her parental house, and again after.
Now, just the sentence before that. If she's living.
Used to live in
The
parental.
opposite party used to live in a parental house. No, no.
Yes, my lord.
Yes.
Without the permission of either me or from my family member.
Yes.
That is there.
And
the opposite party used to leave the matrimonial home and stayed at her parental house. Again, after remaining some
all the
days.
family members who have been misbehaved.
And para 6, my lord.
Para 6.
6, that allegation is there, that I am a grade 4 employee, so Borpeta block.
Allegation, this is of adultery. This has got nothing, you are not pressing this.
During the time of my absence, the opposite party went outside the house independently. When I came to know about, I tried to restrain her, but she didn't listen me and rebuked the opposite party in return before 5 months. One day at about 2:30 p.m., I suddenly came to my house and saw that the opposite party was talking with one unknown boy in my drawing room in an objectionable mood. I asked the opposite party about the boy, and the opposite party told that the boy is the brother of her friend. After that, I came to know that the opposite party frequently met the said boy in different restaurants as well as different places. The opposite party in many times busy with telephone talking with the said boy. The opposite party frequently went to Guwahati by telling falsely to me that she went to her parental house, but met the boy in Guwahati. On 24/8/2017 at about 11 a.m. by taking the advantage of none in my house, the opposite party left along with ornaments, clothes, yes, rupees 10,000, etc. On the next day, I came to know that the opposite party went by white Indica car. I immediately ran her, but she did not receive my call. After a few days, the opposite party called me and told that she will divorce me.
So allegation of cruelty is only in paragraph 5. Very vague. Adultery you are not pressing.
So for the 24/8/17, that incident,
Incident she says that you have
she said that she was found missing.
driven her out by holding her hair. That's
Oh, yeah.
her contention. You said that she
But in her cross, my lord, she stated differently, my lord. There was lot of contradiction.
no, but
To
how
believe that,
you have to stand on your own foot. Whatever she might have said, you said that she had left without informing you. That is your stand.
yes, my lord.
Now that stand will be effective for which purpose? For the grounds of desertion. Desertion, you are not even
Yes, that was not.
you're on the sole ground of cruelty. You make it a case of cruelty from the materials on record. What are the other witnesses? Two brothers. What did they say? Same thing.
So same thing, my lord. They also supported his divinity.
How many family members are there?
He and his soul mother, they are living jointly,
And
his
brothers.
his elder brother, who is DW2, he is living separately.
So brothers will
In the
not
same
come.
premises,
No? Same premises, separate house.
separate house, separate arrangement.
Means
The premise is same, but they live separately. Their kitchens and
what is
things different.
So who stays in your house?
My
mother.
my old mother and
And your wife?
yeah, and wife, she left my house in 2017. That incident, 24.
Thereafter, now
Thereafter, she is living separately, my lord. Since then, she is living separate. From that incident, my lord, that happened.
17 onwards, she is not back.
Yes, she is not back.
Yes, are you intending to live with him?
Yes, Your Honor.
Are you interested to live with him or?
Yes, Your Honor. We are not pressing for the divorce. Lordship. And Your Honor,
Why haven't you gone back to his place, to your matrimonial house?
Lordship, the things that happened, and after on 24th, Lordship, I was thrown out from my house. Lordship. Then just to take a plea that he did not throw out of my house, so he filed a case 2 days later of a missing person. Then I was found by the police at my own house, at my paternal house. Then he went. Then it has been said in the evidence also that he threatened me and also threatened me and said anything may happen to me. So that's why, Lordship, I am not going to that house. And at the meantime, Your Honor, one maintenance case is also pending in the lower court, right?
You have an issue? No issue.
No issue.
Till now, no issue.
No.
But with this kind of friction, will it be able to live together?
Your Honor, I just talked with them yesterday and I had even taken instructions. So they are still, they are not reluctant to give the divorce and
They are not reluctant, they are reluctant not to. Not
Okay.
reluctant, they are reluctant not to give. the
Not
divorce.
yet. Your Honor. And on the basis of the, Your Honor, if we come to the ground, Your Honor, page 4, Your Honor, the para 6, Your Honor, that on 24/7 at around the para
No,
6
that's a
is,
different aspect. If you want to contest, you can contest, but
we have
as a
contested.
practical aspect,
Yes, Your Honor.
with this kind of friction, is it able?
We already talked with them. We also, we
Why
also,
to settle the matter? Go for a mutual consent divorce. Matter ends there.
but Your Honor, we extensive to talk with them because it's a, we know that it's a matrimonial issue and we also said about the consequences. That if you don't give the divorce, then he will have to, if the court passes an order against the petitioner, appellant, then he has to go to Supreme Court, and these are the things you have to think about that. But they have said that they will speak with us. So I have clear instruction regarding that. Thank you. Haven't we tried to have?
What is the
Captain.
maintenance you are getting?
Nothing, Your Honor. As right now,
In the maintenance case you had filed?
in years after this divorce, maintenance case was filed.
What has happened there?
It is being done by someone else, some other advocate, but I have just contacted with him and we have just, I got instruction that nothing has been given to me till now.
So this divorce proceeding was instituted in 2018.
Yes, Your Honor.
You are living separately since 17.
Yes, sir.
24/8/2017. No, 17. What do you do? Are you working somewhere?
Nothing, Your Honor.
And you are a grade 4 employee?
Yes, my.
And Your Honor, the main thing is that they have brought some very.
Okay, we'll come back at.
Yes, Your Honor. Always.
Yes,
That evidence of PW, that one.
yes.
There are 6, my lord, again. PW1, my lord. I'm a grade 4 employee of Borpeta Development Block.
You're reading, it's a part of the is the records.
Yes, my.
PW1.
PW1.
We have read this. Do you want to point out anything special in that?
Yes, my lord. Regarding that incident 24/8/2017, my lord.
Yes.
She left the house without his knowledge, and she has taken away the ornaments and the cash amounting to rupees 10,000, my lord. That allegation is there so far. And that has been in the evidence of others also, PW2 and PW2 basic specifically he also supported. And
Two is your brother.
2 is his brother.
Stays together.
Stays together in the same campus.
Okay.
They are sharing different kitchen, but they are same campus. Right? And PW3 also.
Hindu marriage actually.
He also supported the previous. And so far, my lord, that so far that evidence is concerned regarding the incident of 24/8/17, my lord.
Yes.
So it is put so far they made an allegation that they did not leave the house willingly. She was compelled. She was assaulted.
Yes.
And under that circumstances, she was compelled to leave the house. But so far, that is a story made out by them, my lord. That is apparent on their evidence. May I take your lordship to their evidence in chief, my lord? Yes, Nikita. More you take it up. Post examination. Oh, yeah. So, PW kita কি হবে? Lordship, first examination in C DW1, my lord. It is in vernacular.
Yes.
বিবাদী পক্ষৰ এক নং সাক্ষীৰ পত্ৰ শপত মই শ্ৰীমতী নিৰ্মালী বনিয়া দাস বয়স 28 বছৰ স্বামী নৱজিত কুমাৰ দাস তেওঁ মাইলৰ এক দণ্ডাধিকাৰী মোৰ স্বামী দৰখাস্তকাৰী মোৰ স্বামী নৱজিত কুমাৰ দাসে সুযোগ ৰায় গোচৰ মই অপৰপক্ষ দৰখাস্তকাৰীৰ সৈতে যোৱা 27/9/2022 চনৰ হিন্দু বিবাহ পদ্ধতিৰে মোক বিবাহ সম্পন্ন হয় মাইলৰ So far, I am on the paragraph number 7, my.
7.
Yes. The paragraph 7.
Yes.
Marpit করে শেষ no, মাৰপিট কৰি শেষ নোহোৱাত অপৰপক্ষৰ দেউতাকে her father 27/1/13 তাৰিখে 20,000 টকা কেওকুচটো দি দৰখাস্তকাৰীকে Lordship may turn to para 10, my lord.
10, yes.
Yes. This is the relevant
Ọৱশেষত।
part. Para 10.
Yes, please read.
অৱশেষত নানান অত্যাচাৰ মাৰপিট কৰি যোৱা 24/17 তাৰিখে দৰখাস্তকাৰীয়ে অপৰপক্ষক ঘৰৰ পৰা চুলি ধৰি উলিয়াই দিয়ে মাইকক তেতিয়া উপায়হীন অপৰপক্ষই ফোন কৰি তেওঁৰ দেউতাকক মাতে দেউতাকে ভাড়া গাড়ী লৈ আহি সেইদিনা অপৰপক্ষৰ নিজৰ ঘৰলৈ লৈ যায় দেউতাকে ভাড়া গাড়ী লৈ লৰ্ডশ্বিপ লৈ আহে and DW2 also on the same contention, my lord. DW2, we can see this para, my lord. Para para 9, my lord. Para 9. ইয়াতো সন্তুষ্ট নহয় দৰখাস্তকাৰীয়ে অপৰপক্ষ
Now, what are you trying to show from here?
Lordship, they made a story, my lord. In their evidence different. There was no corroboration. There was no consistency in there. That is what I want to, because that
See,
was
they are
not
the
taken into
defendant.
consideration by the
They are the
trial court.
defendant. They are the second party.
They are the second part.
Second party can have wavering stance. But what do you want to
They
derive from that?
try to establish that their case because she was compelled to leave my house because there was a cruelty on my part, my
Yes.
lord. So my ground is also cruelty, my lord. But
No, you cannot take cruelty if she has alleged cruelty against you. You are trying to get a decree of divorce saying that she was cruel to you. Her allegations will not support your
so
case.
far this incident is concerned of 24/8/17. This story is made out by them, my lord. In their evidence, there is no corroboration, my lord. Who is
Yes,
the
where-
trial court below appreciated, my lord.
What is the where is the necessity of corroboration? It is her version that on so and so this has happened. So I called my father. Father came with a rented vehicle, took me away.
So far, my evidence is concerned, my lord, regarding that incident, my lord.
Yes.
It was not rebutted by them and that was supported by.
She had gone away.
the-
Suppose let us accept your case that she had gone away without informing you on 24 on that same day, 24/8/2017.
Yes, my
Let us discard their case. Will it be enough to pass a decree for cruelty? It is not of desertion.
That was done repeatedly also on earlier occasions, so also without the consent and without the knowledge of the applicant. She used to leave the house.
Yeah, Hindu marriage sacrament
That
on
is-
an incident of this
And
nature.
apart from that, so
corroboration.
far that adultery also, that is not also taken as a ground. Yet the adultery also amounts to cruelty, my lord.
Where are your
Because
statements?
because in the plane itself and in his examination in chief also that joint photograph. There was an allegation, my lord, against her.
But that could not be proved by PW1, PW2, or PW3. Your Honor, we must come to the.
We'll come to his.
Yes,
let
yes,
him
Your Honor.
finish.
Your Honor.
That allegation, my lord. So far the adultery is not taken as a ground, my lord.
Adultery. Let us see the offense of adultery. What is adultery? IPC.
Uh, Forty-nine.
You are the husband.
Yes, my lord.
Have you seen the definition of adultery? What is adultery? Will it come in?
Having extramarital relation, and in a confined.
No, no, no. You go by the definition in the IPC. Don't just use it in a. You're not a layman. 497. You take this IPC.
497.
You have the IPC?
Yes, my lord.
Read 497.
Yes, my lord. Whoever has sexual intercourse with a person who is an he knows or has reason to believe to be the wife.
Wife of another person.
Yes, my lord.
It's not applicable in your case. Had it been the wife, the first party, matter would have been different.
Yes. There. So regarding that, no.
You have one of the grounds, 13.1, but that is not one of the grounds available, but that is not taken as a ground at all. After solemnization of marriage, has voluntary sexual intercourse with any person other than his or her spouse. This was available. You have not
It
taken
was
that.
not taken in
And
the
there is no
plea.
evidence.
Yes, my.
Only talking over phone or something like
Yes,
that.
yes, my.
That will not.
So far, on that day, 11 day, 24/8/7, my lord, that joint photograph. But
That is
that
too
was not.
vague, too vague. You've not even said anything. Leave
Yes,
aside
yes.
photograph.
But regarding what I am submitting, my lord.
See, you have to stand and stick to a point that the case of cruelty has been made out. The grounds which you have not taken will not be available to you. Now I have to see. We have to see whether you have been able to make out a case of cruelty. Statements are very vague. Evidence is vague. You have not even given who are the family members, what are the dates, what had happened. That is only the purpose of allowing you to permitting you to adduce evidence. You elaborate your case simply because you're saying cruelty.
She left because she left his house without his consent, my lord, that they're taking all these ornaments and all.
What
By
is, the
making.
what is your cross-examination on her, chief? That's
Yes, 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 cross-examination.
Yes, let us see the
Yes, my lord.
cross-examination.
DW, my lord.
No, no. Currently,
DW1, my lord.
DW1, yes,
The wife.
yes.
Cross, my lord. I married with the petitioner Navajit Das in the year 2012, and we continued our marital life nearly about 5 years before separation. We have no use from our wedlock. In the month of August 2017, I went missing from the house of my husband petitioner. In that case, police recovered me from my father's house, and police produced me before recorded Porpeta, and my statement was recorded at court. It is not a fact that I had illicit relationship with a person with whom I eloped from the house of the petitioner. It is not a fact that as I eloped with a person whom I had love affair, as such affair was filed against me by the petitioner husband. Though I mention in my evidence in affidavit that my husband committed mental and physical torture on me since long, however, I did not file any complaint against my husband petitioner in any police station. I had filed another case at Mangalore Court under section 125 CRPC claiming monthly maintenance from the petitioner husband. It is not a fact that I behaved badly against my husband and his family members during the continuation of our marital life. It is not a fact I call my lover in my marital life in absence of my husband, and whenever the family members of my husband raise objection to that, then if I behave rudely with them. Petitioner is a grade 4 employee, so and so, my lord. However, I do not know as to how much monthly salary drawn by the petitioner. In the house of the petitioner, mother, brother's wife, and one of their child live together in a joint family. I also lived with them when I was in the house of the petitioner. It is a fact that my husband petitioner is the sole bread earner of his family, and my husband bear all household expenditure for running his family. It is not a fact that during our conjugal life I harassed the petitioner in various ways and always disobeyed and will behave with him well.
Where is your question regarding 24/8/2017? That what she had said is entirely wrong. Father had not come. There is no
Oh.
question. Not even a suggestion.
In the month of August 2017, my lord, in the cross,
Yes.
I went missing, my lord.
Yes.
She contended that she went missing.
You had filed a missing report.
I filed a missing report also.
In the chief, it has been explained.
But so far, the DW2, my lord, the cross,
Who's DW2?
father of the
Okay, what did he say?
My advocate prepared my evidence in SIP, but I did not read over it to me. However, it was prepared as per my version. I visited the house of my son-in-law only once after the marriage of my daughter with him. After 1 month of the marriage of my daughter with the petitioner, my daughter was found missing from the house of the petitioner. Then my son-in-law and their family members came to our house for making inquiry about her. Then I came to know about my daughter's missing. I thereafter informed the matter to police, and a missing report was registered at Porpeta PS. My son-in-law left my house on that very day, and my daughter reached my house after 2-3 days of that incident. On inquiry, my daughter informed me that she came to our village and took shelter in the house of one Nogen Koli. Nogen Koli, whose house is 1 kilometer away from our. My son-in-law never make any allegation against my daughter before me. When she was in the house, before solemnization the marriage of my daughter with the petitioner, I paid rupees to him. However, I could not remember that months and year on which date I paid the. It is not a fact that I did not pay any amount of money to the petitioner before their marriage. It is a fact that I didn't inform the matter anyone before our village elders that the petitioner physically assaulted on my daughter, but I informed before the police and filed a case against the petitioner. It is not a fact that my daughter respondent has no intention to continue her conjugal life with the petitioner, and during the subsistence of their marriage, she had illicit relationship with another person. It is not a fact that my daughter respondent eloped with a person when she was in the house of the petitioner. Petitioner is a government employee, but I don't know his designation and how much monthly salary he gets from his service. Lordship DW3, he was the driver of the vehicle who took the who took the father of the respondent to bring her on that relevant day, 24/8/17. That is in examination in SIP, but here I don't know the contents of my evidence in SIP. The house of the respondent is situated 4 or 5 kilometers away from my house. There's the caste of the respondent is same with me as I knew her. Though I attend the marriage of the respondent, but after marriage, I never visited the house of the father of the respondent as well as the house of the as I never visited the house of the petitioner, as such, I don't know about their conjugal life. I have no knowledge whether the respondent was found missing from her husband's house or not. I don't know anything about the conjugal life of Nirmali Punia, but I have only link with her brother, as he sometimes hired my vehicle for different purposes.
Driver not knowing is not,
He was his
Unnatural.
vehicle. They contended that his vehicle was hired to bring her back home on that day, 24/8/17, when she was assaulted. It
Yes.
was so far they have different stand here.
what difference? He is their witness. In his chief, what did he say? Did he deny? Will he deny in his chief? Produced by the same party?
In SIF also they have different. In SIF also they have different contentions.
Defendants, they have the liberty to have wavering stance. Plaintiff, you cannot have two stance. They can take any number of defense.
In examination in SIF regarding her, that means they recovered her. So on that LS day of incident, my lord, she was assaulted. That was their content. And in their examination, see different stories, my lord. So DW1, my lord, as I have pointed out your lordship, অৱশেষত নানান অত্যাচাৰ মাৰপিটত যোৱা 24/7/17 তাৰিখে দৰখাস্তকাৰিণী অপৰপক্ষ ঘৰৰ পৰা চুলিত ধৰি উলিয়াই দিয়ে মাই লৰ্ড। এতিয়া উপায়হীন হৈ অপৰপক্ষক ফোন কৰি তেওঁ দেউতাকক মাতে। দেউতাকে ভাড়া গাড়ী লৈ আহি সেইদিনা অপৰপক্ষক নিজৰ ঘৰলৈ লৈ যায়। দেউতাকে লৈ যায় মাই লৰ্ড, ভাড়া গাড়ী লৈ গৈ। Then DW2, my lord, her father, দেউতাক, he contended that ইয়াতো সন্তুষ্ট নহয়, পেৰা নাই। দৰখাস্তকাৰীয়ে অপৰপক্ষক মাৰপিট কৰি ঘৰৰ পৰা উলিয়াই দিয়ে। উক্ত ঘটনা যোৱা 24/7/17 তাৰিখে হয়। তেতিয়া অপৰপক্ষই ঘৰলৈ ফোন কৰাৰ ভায়েকে ভাড়া গাড়ী লৈ যায় অপৰপক্ষক মোৰ ঘৰলৈ লৈ। She told her father hired that vehicle, went there, and
Whose version is this?
this is the version of father of the respondent, DW1. This is DW2, father of that his wife, and the driver, my lord, the vehicle driver was as a DW3 at Para 5 mile. দৰখাস্তকাৰী আৰু উপপক্ষৰ মাজত থকা কাজিয়া ভাঙিবলৈ দেউতাক আৰু ভায়েক বৰপেটাত যোৱা কথাও জানো। সেই বুজনিয়ে বিশেষ কাম নিদিলে, কিয়নো 2017 চনৰ আগষ্ট মাহত ছোৱালীজনীক বেয়াকৈ মাৰপিট কৰি দৰখাস্তকাৰীয়ে ঘৰৰ পৰা উলিয়াই দিয়ে। এই কথা দেউতাকে মোক কোৱাত মোৰ গাড়ী অপৰপক্ষৰ ভায়েকে লগত লৈ আহোঁ। ভায়েকৰ কন্যাৰ লগত দেউতাক যায়। ভায়েকৰ লগত দেউতাকো যায় here also. And in his cross examination he said, I never visited the house of the appellant.
No, earlier I had.
In the cross examination of
the cross examination, that was not the
DW3.
driver's cross examination.
Diverse cross examination, your lordship will find DW3, he as a DW3.
DW3.
What is the name?
His name is.
I do not, I don't know.
Yes, his name is Novokanto Bonia. I don't know the contents of region that the house of the respondent is 4-5 kilometers away of that. As the caste of the respondent is same with me, as I know. And I attend the marriage of the respondent, but after marriage, I never visited the house of the father of the respondent as well as of the
Yes.
petitioner. As I never visited the house of the petitioner, as such, I don't know about their conjugal life. I have no knowledge whether the respondent was found missing from her husband's house or not. I don't know anything about. My lord, I don't know anything about the conjugal life of Nimali, but I have only link with her brother, as he sometimes hired my vehicle for defense.
This I have never visited is not the present visit. It is on the context of knowing about their conjugal life earlier.
As I
Though
never
attended
visited
the
the
marriage of the after marriage, I never visited the house of the father of the respondent,
and
as well as the petitioner.
I don't know anything about conjugal life of Nirmali Bonia, but I have only link with her brother, as he sometimes hired my vehicle for defense. But even then, my lord, there is no cooperation.
Okay.
So they made out a story, my lord, that was the story. They wanted to prove that cruelty was also against them. So that was appreciated by the trial court. And so far, she left the house without my knowledge, and before, prior to that also, she used to leave my house without my knowledge and consent, my lord. So that also amounts to cruelty, my lord. So far, I have referred to the judgment. Deliberate course of conduct to harden and humiliate me, my lord. I have referred to that judgment, your lord. And the judgment, although it was discussed at this party, wife is compelled to leave the matrimonial house and to live separate for whatever period of time maybe, otherwise his husband, after driving out of his wife from the matrimonial house and compelling her to live separately for a consideration period of time, to be able to get a decree of dissolving the marriage on the ground of the same being irritably broken down. So he is guilty of such separation, and the argument forward by the counsel of the marriage be dissolved by decree of divorce on the ground of the same being irritably broken, cannot be accepted, hence rejected. On the basis of those evidence, my lord, trial court considered that she was compelled to leave the matrimonial house. And on the basis of that, the decree of divorce on the irretrievably broken down on that ground, my lord, the divorce could not be granted, and that ground could not be accepted by the trial. Because the trial court findings were that she was compelled to leave the house. It was the fine.
This ground is otherwise not a legal ground. It's not in the law. If you find a law ground of irretrievable breakdown, it's something evolved by the Supreme Court under 142. Not even, we are also not entitled to pass a decree on that.
So far regarding that, my lord, very precisely, my lord, the case is extended to that only, my lord, on the incident of 24/8/17.
কৰিছিলে কিবা আছে আছে কিন্তু সেইখিনি প্ৰমাণ কৰিব লাগিব নাই সেইকাৰণে বাৰে বাৰে সুধিছো যদি মিউচুৱেলি একচেপ্ট কৰিলে তেতিয়া এটা এলিমেণ্টে ভাল কথাটো আহি পেলাই শেষ কৰিব পৰা যায়
Yes,
Yes, Lordship. Lordship,
what is your name?
I'm Burwayo. Lordship. Lordship, basically, we have to look at the grounds, Your Lordship. They have put the grounds
Yes.
that first, page 7, B. 7, yes, Lordship. For a learned court below failed to appreciate fact that on 24/08/2017 at around 11 a.m., respondent left the house of the appellant, taking ornaments, clothes, and cash rupees 20 with her, taking advantage his absence and other family members at home. Hence, the appellant filed a complaint FIR at Borpeta police station about missing of his wife on 26/08/2017, which was registered as MMR number 48/2017. This is one of the grounds, Your Lordship. Then, if we come to the second ground,
This is the second ground.
yes, it's the second ground. Then the third ground, it is that page 8, last para, the learned court below appreciated torture was instituted and respondent was compelled to leave the house of the appellant merely based on statements of the respondent's side by negating the facts that she left the house of the appellant willfully without knowledge and consent of the appellant. And this connection, aforesaid complaint of missing was lodged before Borpeta PS. It is pertinent to mention herein that though the respondent apprised the learned court of lodging complaint, the same has been instituted March later as a counter after filing of the appellant's aforesaid title suit, and such the impugned judgment. Then fourth is page 9, Your Honor. Your Lordship, then there's the brother of the appellant as PW2 adduced evidence regarding her extramarital affair with a boy whom he saw and found gossiping in appellant's house. However, the learned court below did not consider the same by taking ground that the appellant's brother never saw the respondent and the boy in compromising mood. As such, whether such impression is sustainable in the context that as to whether compromising state of mood is inevitable for fixing charges of extramarital affair. Then in page 10, the ground that has been taken for a learned court below failed to appreciate that the appellant had gone through excessive mental torture and there was also serious threat and danger of his life as the respondent maintained extramarital illicit affair with the said unknown boy, and the respondent also constantly threatening the appellant by misbehaving with abusive language. She even maintained her said alleged extramarital affair with arrogance and courage by ignoring the appellant, which put his life in serious agony, torture, and threat. The respondent, having been involved in extramarital affair, created serious threat or danger to appellant's life. These are the grounds that has been put forward. There is nothing regarding the evidence or any kind of thing that the cross-examination has not happened. In the cross-examination, there has been some wrong things have been said or that have been not corroborated. Then, Lordship, regarding that thing of 24/08/27, in the there had been in page 31, Your Lordship, the issues has been discussed, and the main issue in para 4, 3 number, whether the defendant treated the plaintiff with cruelty in course of their matrimonial life and whether the defendant deserted the plaintiff. That is the main issue that has been dealt by the trial court. And in issue 3, uh, in issue 3, Your Honor, Your Lordship, there is in page 38, the first thing that has been raised in the ground regarding the 2408/2017. In the paragraph in page number 38, the plaintiff further stated that on 2408/2017, the defendant left his house, it should be her house, his house, and on the next day he came to know that she has gone in a white Indica car. In this regard, the defendant stated in her cross-examination that in the month of August 2017, she went missing from the house of the plaintiff, and in that case, police recovered her from house of her father. She denied that she eloped with some other person. Then, Lordship, page 34. Here it has been discussed regarding what happened on 24. The last part of the page, second para. PW1 stated that on 2408/2017, the plaintiff assaulted her and by catching hold of her hair, drove her out from her marital house. Finding no other way, she called her father and her father took her to his house. Since then, she has been residing at her parental house and the plaintiff neither inquired
This
about her.
this cannot be PW, this will be DW1.
Yes, then comes the.
No, it's not PW, it's in.
It should be DW, yes, Lordship. Hence, she prayed for justice. DW2, Prasad Bania, father of the defendant, and DW3, Novakanto Bonia, lend support to the evidence of the defendant that the plaintiff physically tortured the defendant in demand of dowry, and ultimately he drove out the defendant from his house. Then in regarding to the PW, their statement in page 37, Lordship, in the second para.
Yes.
That the plaintiff further stated that one day when he suddenly came to his house, he saw that the defendant was talking with one unknown boy in their drawing room in an objectionable mood. But PW2, brother of the plaintiff, clearly stated in his cross-examination that in absence of the plaintiff, one person came to the house of his brother and was gossiping with the defendant, and he never saw them in compromising mood. He also stated that the plaintiff and the defendant frequently quarreled with each other. PW3 is a hearsay witness. He stated in his cross-examination that the plaintiff used to inform him about the happening between him and the defendant. The plaintiff took another plea in his WS that the defendant has illicit relations with some other person, but the plaintiff and his supporting witness did not say anything in their evidence to support the plea of adultery brought against the defendant. This is all, Your Lordship, that they could not prove in the trial court regarding the cruelty part and the adultery part. And even in the grounds that they have taken in this present appeal, they have taken the ground of that
This is the
24-0.
first appeal, they can take any other grounds.
Yes,
It's not confined to the grounds taken.
but they.
You have to meet the arguments made by your learned colleague. You cannot, it's not confined to the specified
Yes,
grounds.
yes, perfect, yes. But in the appeal, they have not stated that they can take any ground at the time of the hearing or anything. No prayer
Not
was made.
required.
No prayer
Not
was made.
required.
Yes.
It's a first appeal.
So, the Lordship side, we think that this order should not be, this order should be maintained as it is, because I have also taken instruction from the person also, the wife, and she is on of the state that she is not inclined to give the divorce.
Why do you think that a case of cruelty is not made out?
Cruelty is not made out because
Leaving aside the incident of 24/8/2017.
Yes.
Other averments and other materials on record, including the evidence of PW1 and PW2.
if we see, Your Lordship,
Your temperament, your behavior towards his mother,
yes,
to the other family members.
if we see, then the thing goes back after the marriage, Because after the marriage, what happened? If lordship comes to page 30,
1-3.
30. Why this all things have been happening? Page 30,
Yes.
the defendant in her written statement submitted that since after their marriage, her husband and the mother-in-law used to insult her and torture her physically, that the Sridhan articles given at the time of her marriage are of below standard. After 3 months of their marriage, the plaintiff demanded rupees 2,50,000 from her parental home, while she expressed her inability to fulfill the demand. The plaintiff subjected her to physical and mental torture. She informed the matter to her father's home, and her father and brother arrived at her matrimonial home and understand them to lead a peaceful marital life. But after a few days, the plaintiff repeated his cruel nature. Having no alternative, her father paid rupees 20,000 to the plaintiff on 27/01/13, just a few months after the marriage. But the plaintiff was not satisfied with the amount, and he again started torture on her and did not provide her proper food. Then her father paid rupees 80,000 at the hand of the plaintiff on 18/08/2014. But thereafter, on 24/08/2017, the plaintiff assaulted her. This whole thing has been happening after the marriage. So I have been subjected to cruelty. I have been subjected to give money from my father after just after the marriage, and all these things are happening. And they could not prove anything about cruelty or all those things in the evidence or at the time of the trial. Only they have stood by the 24/08/2017 incident.
You are not willing to for a mutual consent divorce, but there he has failed in his endeavor to seek a divorce. But the chances of a revival is we do not see at all. Why don't you end up the matter?
We've already talked with
What
the
do you
appellate
gain?
also, and also we talked with yesterday. I just had the
No,
discussion
no,
with her.
that we know, but you are not going to come back. Suppose this case is dismissed and there is no decree of divorce, but you are not going to come back. Are you willing to come back?
As I talked with her yesterday, she is ready to come. We have taken instruction from clearly taken instruction, and we have also told about the consequences of what may happen in future. So I have to stood by the instruction.
Mutually consented যদি এগ্রি নকৰে তো সেইটো কৰিব আহিম বুলি কৈছে ক'ত আহিব নাই দুইটাৰ লাইফ বৰবাদ
Now see what will be the result of the this appeal, that we cannot say, but it may go either way. So if your petitioner, I mean your client is staying separately since 2017, so long say 6-7 years she is staying separately.
She has
more
tried
than
to
7
mend.
years.
In between, she has tried to mend, but things have not come out. So we have already tried that anything can be, but the husband is not ready. But I am ready. That is the part.
You are still ready.
Yes. I have.
Do you think that will it be possible to come again and stay with him in that circumstances?
Your Honor,
Otherwise, the order will be
Yes.
passed. That is okay. But we are just
Yes.
asking you because
Actually we took some time. We actually discussed with in length, and even yesterday we talked with them personally. And yesterday also they relented that they are ready to go back, and they are not ready to give their consent in this divorce. And as per the information I have got, that there is also a maintenance case also pending, and not a single penny has been given to her.
So far, my instruction is concerned, my thought she never approached that she will come back, something like that. whatever my learned printed.
Not directly, but
No,
your-
my lord,
my
that
lord,
endeavor was not made anymore, my lord.
No, your appeal was pending, is pending, so there is no, at that time, how can she come? You are challenging the
Even during the
order of the
pendency of the
family
appeal
court,
also.
the
Yes.
refusing a decree.
We filed the appeal.
whether
It is filed on
whether
2022, my lord.
order pass হয়েছে
11 March
order was
2022.
passed decree was passed on 17/11/2021,
5 years prior to that also 5 years.
but
He
in
was
between
living
all these
separately.
things were going on. The trial case was going on. Then after that, they filed this appeal against the divorce order.
Lack of materials. इन लोगों को तो भेज दी आपने इन लोग कहाँ नहीं फोटो they are a great party you put a 1 minute request you can now put one okay heard so the records of the learned family court has been periled. Hearing is concluded, judgment is reserved.
Obliged.
Yes.
May it please your lordship. Well, as I said, this is an appeal against conviction for life for an offense under section 302. And the name of the appellant is Chauhan Ali. And the date of occurrence is Malak 27/9/2013. Oh, may I type back in that? May I type back?
Yes.
The one second, let's put it there. The lordship will kindly look into the affair first at page 4. I have a original type copy of the affair, my lord. Your
Doesn't
lord.
matter, doesn't
Yeah. Exhibit 111.
Yes. You can refer to the paper book, no
Yes.
problem.
There's some mistake in the translation, my lord. So that's why I had also brought a type copy of the affair. I have the honor to state that around 5:30 p.m. on 27/9/2013, the accused persons named below were hiding near Hassan Ali's house in a pre-planned manner, armed with dagger, thou and spares. Your lordship will take note that in the FIR they say it is thou, dagger and spears. Time 5:30 p.m. of March 27th. And your lordship will also suddenly attack and severely assaulted my younger brother and my son while they were coming from Gaspa. Accused Shurab and Shohan tried to killed Siddiq and Ainuddin respectively by stabbing them with a dagger and dagger. However, hearing the scream, the neighbors came forward. Neighbors came forward and found them still alive but bleeding profusely. The accused person snatched an amount of rupees 30,000 and a mobile handset from the pocket of the injured person. Although the injured persons were later admitted into Dhuri hospital, they are fighting for life. Lodging of the FIR got delayed as I was busy in taking care of both the injured. I therefore pray you to register a case and investigate the matter. In the FIR, 7 accused have been named, and my name figures at serial number 2. There is spelling mistake, but so far the SMS vernacular is concerned, it is Suhan Ali. Now, charge sheet has been submitted, my lord. Your lordship will find the
This informant is PW1,
yes, ma'am.
Aswaruddin.
Yes, ma'am. Now your lordship will see the charge sheet first. Right, sir. At page 90 of the paper book.
Page
90. Four accused have been charge sheeted at page 90 at 91.
Yes.
Now your lordship will look. The first error which has crept into is at page 7.
Page
7 of the paper. The head of framing of charge, page 7. Then your lordship will find name of the accused person. Your lordship got page 7.
yes.
Name of the accused person charges Hussain Ali, Subhan Ali, Tabur and Saurabh Ali. Now you also will find first that you on 27/9/2000 at around 4:30 p.m. at village Ghaspara under Dhuri police station, you were a member of an unlawful acceptance.
That is okay.
that-
Five is
So this
for that trial will
for-
not be vitiated. It cannot be an unlawful assembly.
this 141 will go. You have to attribute the individual
That is
act
okay,
to,
that is okay.
to each of the orders. Now your lordship will see the evidence of PW1 at page 10.
But just a minute, just a minute. Before you say that, put in the FIR, there were 7 numbers of persons.
Yes,
So it was indeed an unlawful assembly under 141.
but
So, but what is the narration? Please read at page 7. That on so and so, 4 persons have been charged,
yes,
but they were members of an unlawful assembly, which were 7. Had the FIR been of less than 5, then your arguments would have been considered. Now, I think that will not make any difference.
depends. And
Obviously,
more-
the conviction cannot be related to 141 because
Yes.
140 now.
yes, you have to look for the individual
that
acts.
that we are clear.
That you have to look for the individual act.
Yes.
Now your lordship will see, I'll take all the witnesses are their family members. Although in one of the deposition of the witness, we find that it was held in a neighborhood which is quite busy, but there is no independent witness. And although the assault took place on 27, the deceased died later on after 3 days in the hospital. On 1st. And your lordship will not find that there is no explanation from the investigating officer why, in spite of having 3 days, why the dying declaration of the deceased was recorded. And your lordship has seen showed dagger lathi. Although a dagger was seized, but no forensic examination of the dagger was done. Lathi and showed never recovered. And even the dagger which was seized was not exhibited during that material object was not exhibited during the trial. I'll take your lordship to the judgment.
What was not recovered? Lathi and
Lathi showed,
sword. Oh.
and if your lordship looks into the exhibits at page 83.
Mhm.
It doesn't, the dagger was also, although seized, not sent for
Forensic.
forensic, and neither it was exhibited during the court, in the court, during the trial.
Then
So,
it was not a material exhibit.
no,
Dagger not material exhibit.
that's why I'm pointing out to your lordship at page 83. The list is given, man, at page 83.
So the recovery of that is
That
out,
goes.
that out.
That, now your lordship will see. At page 10, the first, the PW1. We'll go serially, my lord,
Yes,
because
yes.
5 witnesses are there, then the doctor, then the investigating officer, doctor who examined the injured, and the doctor who conducted the postmortem. I know the accused present today in the court.
He is
I-
the informant.
In,
Assaruddin.
yes, ma'am. Asharuddin Mandal. There were some contradictions during the examination, but those contradictions now I find, my lord, in the earlier order rejecting my bail. The court looked into the original transcript of the 161 statement to really see whether those were made during the investigation or not. But now first let us confine what is recorded in the doc. I know the accused person present today in the court. I also know the injured and the deceased. That means all are known. On 27/9/2013 at around 5 to 5:30 p.m., I came to the riverside. He said that I came to the riverside. Having arrived at the bank of the river, I heard hue and cry. I had also noticed Tahir Ali and Soban Ali armed with sticks coming round to the place of occurrence. So this witness says that Tahir Ali and Soban Ali armed with sticks coming round to the place of occurrence. So this witness doesn't say that any of these accused persons was carrying any dagger while going there. Then he said, there I had seen Ainuddin Mandal was trying to catch hold of the knife in the hand of Soban Ali. So this knife was already there in the hands of the other accused. There was a cross case, but that was also not effectively, that cross case was not highlighted. I can't take benefit because whatever is there in the evidence, I have to concentrate on it. So it prima facie, it shows from here that the dagger was there in the place. There I had seen Ainuddin Mandal was trying to catch hold of the knife in the hand of Soban Ali. Sohrab Ali, by means of stick in his hand, striking blow on the scalp of Ainuddin. This Sohrab Ali, my lord, was convicted, my lord, I just confirm once. Exactly. Just 1 second. Attack 323 conviction. This Sohrab Ali, my lord, which is referred here, was convicted only under section 323 IPC and given a fine of 1,000 only. This Sohrab Ali, who had struck Sohrab Ali, by means of his stick in his hand, striking blow on the scale of Ainuddin.
He is convicted under
323 and given only a sentence of 1,000 rupees fine. Then your lordship will see the next line. Ainuddin fell down on the ground. Shobhan, by means of the knife, stabbed on the right side of the belly of Ainuddin.
yes.
Oh. There's some typographical errors in so far Ainuddin is concerned, but it is Ainuddin only. Tahir was tightly holding the neck of Siddiq Ali. Siddiq Ali had fallen down on the ground. Siddiq Ali is the deceased, my lord. And then he had seen Soban armed with the dagger was running after me. I was saved at the timely intervention of Ajibor and Saddam, who had intervened and removed the dagger from the hands of Soban. This Ajibor and Saddam are also witness number PW2 and PW3. I had taken both injured person, Ainuddin and Siddiq Ali, to Dhuburi Subi Hospital. Ainuddin had undergone treatment at civil hospital. Siddiq had to be shifted to GMCH. Since his condition was serious, Siddiq succumbed to his injuries after 3 days stays at the GMCH. So, my lord, I'll later on, my lord, this 3 days stays at the GMCH, my lord, that can be a circumstances which your lordship can look into. Suppose if your lordship decide that I am not entitled to a full acquittal, then at least that circumstances for not recording the dying declaration can be a ground to convert it into 304 part 2. That's why your lordship will pause here and kindly take note of it. I'll come later on to it. Then cross is reserved. Now your lordship will see the suggestion put during the cross and how the cross was conducted on PW1. Because the suggestion, the defense was trying to build up their own story. I had been interrogated by the IO on the day of the alleged occurrence. I was at my house. Now in the chief, he says, I came to the riverside having arrived at the bank of the river I hear. But here he says, again in the cross, he says, on the day of the alleged occurrence, I was at my house. Well, your lordship will find when your lordship goes to all the evidence of the 5
Now, let
witnesses.
us read further.
Yes.
He might have been in the house. There.
Yes,
Let us see.
The place of occurrence is around 200 to 300 meters away from my house, which is on the other side of the road. The time was around 5:30 p.m. It was immediately before evening prayer time. The place of occurrence is located at a densely populated area. Although it was a densely populated area, the investigator officer made no effort to take any independent witness. Anwar Johirul is PW5, my lord. Sanwar, Bahadur, Surat, Hussein Ali, Mughal, etc. All residents living in the neighborhood of the place of the occurrence. None of these residents had seen the occurrence. There is a BSF post near the place of occurrence. Ajibur, that is PW2, is my nephew. Ainuddin, PW4, is my brother. And Johirul Haq, PW5, is my brother-in-law. All related. Immediately after the alleged occurrence, many people had gathered at the place of occurrence. I had not told about the incident to any of them. I am one of the accused person in the case filed by the accused persons. So there was a cross case and he is also one of the accused. In the cross case, the FIR was lodged alleging that we attempted to assault the informant and the witness. I had not noticed any injury on the person of the accused. It is not a fact that we had caused injury to Subhan Ali, Tahir Ali and Aji Ran, and we threatened to kill them on seeing them coming on a boat. The BSF personnel remained on guard in the evening at the BSF post. The international border between India and Bangladesh is located around 300 to 400 meters away from my house. It is not a fact that we, along with some other persons, had attacked the present accused person. I had not written the FIR in the present case. Since my son had died in the alleged occurrence, I filed the FIR. The contents of the FIR was read out to me before the FIR was lodged. The name of my deceased son is Siddiq Ali. Before the alleged occurrence, my younger son, Saddam Hussein, had divorced his wife. About 8 months after the occurrence, my second son, Saddam Hussein, married the widow of Siddiq Ali. It is not a fact that my son, Saddam Hussein, had illicit relationship with the wife of Siddiq Ali, for which Saddam Hussein had divorced his wife. I had received injury in the alleged occurrence, but I did not take treatment. I had not told in my statement before police about having received injury in the alleged occurrence. That will come again during when the IO is cross-examination. Siddiq Ali and Sorab Ali were coming to Dhubri on boat. Shall not be able to say how many persons were on the said boat at the relevant point of time. The place of occurrence is ferryguard. One Salam is the lessee of the ferryguard. I do not know who was operating the boat. There is no electricity in the place of occurrence. It is not a fact that I had not seen the occurrence. It is not a fact that I have filed false case against the accused person. It is not a fact that I had not seen accused Sobhan striking knife blows at my son. It is not a fact that since the villagers had seen the occurrence and in order to suppress the material fact, I had not adduced the evidence of any of the villagers but made members of a family witness. It is not a fact that the seized dagger belonged to us and not to the accused. It is not a fact that I had not stated before the IO about Sobhan striking knife blows on the right side of belly of Ainuddin and about Tahir Ali holding tightly at the neck of Siddiq Ali. It is not a fact that Siddiq Ali had fallen on the ground. I had taken the injured to the hospital on a tempo that belonged to one Geda. These are not relevant. So some contradiction is sought to be made out in this statement. Your lordship can look into the IO now, or your lordship will prefer to look it at the end of reading it all.
Let us go serially.
Yes. Now your lordship will see PW2. Your lordship may find the version of the witness somewhat different so far the other parts are concerned, except the stabbing part. All the 5 witnesses have confined themselves that it is Subhan who has caught the stabbing. I know the accused person. I'm reading my lord PW2 page 30.
Just a minute. What is the name of the deceased?
Siddiq Ali. Some say Siddiq Ali, some say Siddiq Hussain. Siddiq.
Okay. PW2.
Yes, ma'am. I know the accused person. I also knew the deceased Siddiq Hussain. He was my first cousin. About 3 years ago, one day at about 4 p.m., along with my cousin Saddam, while I was proceeding towards a grocery shop at Sasterghat, Part 1, we heard hue and cry on the eastern side. Then we went to that place and saw the accused Sobhan stabbed Siddiq on the right side of his stomach by means of a knife. Thereafter, the accused Sobhan attempted to stab father of Siddiq, namely Asuddin. Then I caught the hand of the accused Sobhan. Thereafter, I and Saddam snatched away the knife from the hand of the accused Sobhan. The accused Taher, Ainuddin and Johirul were also present there, and I saw injury on the head of Ainuddin and stick on the hand of accused Ainuddin. So Ainuddin also had stick in his hand. Thereafter, we took Ainuddin and Siddiq Ali to the Dhubri Civil Hospital. Doctors of Dhubri Civil Hospital told us that the condition of Siddiq Ali was serious and advised us to take him to GMCH Guwahati. Accordingly, on the next day, Siddiq Ali was taken, immediately not taken. Accordingly, on the next day, Siddiq Ali was taken to GMCH Guwahati. After 2 days, I heard that Siddiq Ali has expired. Later on, the investigating officer seized the knife in my presence and took my thumb impression in the scissor list. Then on behalf of accused Sobhan Ali, Abu Taher, the informant is my paternal uncle. Beside the accused also, I saw Ainuddin, Asuddin and Zahiruddin at the place of occurrence. That is all family members. He said that to establish the occurrence, he says that he has seen all the accused at the place of occurrence. On the eastern side of the place of occurrence, the land of Ainuddin, and the western side, the land of Zahirul are situated. Zahirul happens to be the brother-in-law of the informant Asuddin. On the far western side of the place, the houses of Anwar, Sanwar Ismail, Gyasuddin, Hassan Ali are situated. There was no BSF camp near the place of occurrence. The houses of the accused are situated at a distance of about 300 meters away from the place of occurrence. On the day of the death of Siddiq, the police recorded my statement. It is not a fact that I did not see the incident. It is not the fact that as the deceased Siddiq was my cousin brother, I have implicated the accused falsely. After the murder of Siddiq, my cousin brother Saddam married his widow. Earlier, Saddam had married another woman. She has left the house of Saddam. It is not a fact that Saddam Ali had illicit relation with the wife of the deceased Siddiq, and he had murdered Siddiq. I am an accused of the case filed by the accused Sorab Ali. It is not a fact that we transferred into the house of the accused and assaulted them. I handed over the knife to the police. It is not a fact that the said knife belonged to me. It is not a fact that as I am an accused of the case filed by the accused, I have deposed falsely against the accused. Then your lordship will find the next. The police had recorded my statement after 3 days of the incident. At the time of recording my statement, Surat Ali and his wife member Anwar Hussain and other witnesses were present. My statement was recorded in the house of Surat Ali. The house of Surat Ali is situated at a distance of 500 meters away from the place of occurrence. I showed the investigating officer the place of occurrence. I did not tell the police that hearing a noise, I went to the place of occurrence and saw. This is your lordship will take note. I did not tell the police that hearing a noise, I went to the place of occurrence and saw that the accused Sobhan Ali was trying to assault my uncle Asaruddin Mandal by means of a dagger. And I caught the accused Sobhan Ali with the dagger, and Saddam Hussein also grabbed the accused Sobhan Ali from behind. I did not tell the police that I snatched away the dagger from the hands of accused Sobhan Ali. I did not tell the police that I have given the dagger that I snatched away from the hands of the accused Sobhan Ali to them. It is not a fact that the accused Sobhan Ali did not stab on the stomach of Siddiq Ali from behind. It is not a fact that the accused Sobhan Ali did not try to stab Asaruddin by means of a dagger. It is not a fact that I and Saddam snatched away the dagger from the hands of the accused Sobhan Ali and stabbed the deceased Siddiq Ali. It is not a fact that Saddam Ali had illicit relationship with the widow of the deceased Siddiq Ali, and therefore we killed Siddiq Ali. Saddam Ali had married the widow of the deceased Siddiq Ali. Now your Lordship will see PW3. Here your Lordship has taken note of the this paragraph. I did not tell the police that hearing on a noise, I went to the place of occurrence. He says that he did not tell the police all these things. These were told first time in the court.
Yes.
Itu witness report. Yeah, minor, so-called BSF camera is not relevant. One of the witnesses, BSF camera is near. The PWD says that there was no BSF cam near the place of occurrence. Those your Lordship will ignore. If your Lordship looks at page 14, your Lordship will find that there was no BSF cam near the place of occurrence. Whereas in PW1 statement, it says that there is a BSF personnel remain the international border. So BSF can is nearby, but that doesn't change the color of the case matter. Now your Lordship will see PW3.
16.
Yes, Saddam Hussein. They have confined all the witnesses within the family members. It is not my case that just because the family members were examined, that's why the case will not be true. But your Lordship will examine it carefully, because when you can have other independent witness, there is no explanation why none of the any independent witness, any effort was made by the investigating officer to record the statement of the independent witness. But at the same time, your Lordship may also say that just because there is flaw in the investigation, you will get the benefit of not examining the independent witness or not. So I was from, if your Lordship looks into all the witness, their family members up to 5. So far this stabbing part is concerned, they are all consistent. Your Lordship will see this witness. I know the accused person. This is Siddiq Hussain was my elder brother. About 3 years ago, on one day at about 4 p.m., along with my cousin Ajibor, while I was proceeding towards the grocery shop Ismail situated at Sastreghat Part 1, we heard hue and cry on the eastern side. We then went to the place of occurrence and saw that the accused Tahir Ali was holding Siddiq Ali, and the accused Sobhan stabbed Siddiq on the right side of his stomach by means of a knife. Thereafter, the accused Sobhan attempted to stab my father Asuruddin. Then I and Ajibor caught the accused Sobhan and snatched the knife from him. My uncle Ainuddin Mandam was lying injured nearby, and the accused Sorab Ali was standing there wielding a bamboo stick. This part, your Lordship will find variation in all the witness statement. Therefore, we took Ainuddin Mandal and Siddiq Ali to the Dhubri's hospital. In a scuffle, the witness may say different, have a different version also. But your Lordship will always see that does it inspires to the evidence to such a level that your Lordship will not look for any other evidence or statement which can throw doubt on the. I as a counsel for the accused only have to create a doubt in the Lordship mind that whether this subsequent which things are there which are believable or not. Even if I don't prove it, that your Lordship may hold it to be proved beyond reasonable doubt. I need to create only a doubt. And if I can able to create a doubt, that doubt will go in the favor of the accused. My uncle Ainuddin was lying injured nearby and the accused Surab Ali was standing there wielding a bamboo stick. Thereafter, we took Ainuddin Mandal and Siddiq Ali to the Deputies Hospital. Then next day, immediately he was not taken to GMCS. Next day, Siddiq Ali was taken to the GMCS Guwahati. But after 3 days, Siddiq Ali has expired. The investigation officer seized the knife in my presence and gave my thumb impression in the scissors. The place of occurrence was about 50 meters away from the river. Near the place of occurrence, the house of my maternal uncle Jahirul is situated. After the house of Jahirul, about 19 other houses are situated. After the incident, about 30% assembled at the place of occurrence. The house of accused Suhan is situated at a distance of about 250 meters away. Now, if your lordship, for a moment, if your lordship pause here, your lordship will find that all these witnesses are not giving the actual genesis of the occurrence of the incident. Why? Wow. Why this incident has occurred? None of the witnesses are given. They are only confining only to that particular part of stabbing and going and saying it. That the genesis of the incident, how it had started, none of the witnesses trying to disclose, my lord. Near the place of occurrence, the house of my maternal uncle Jahirul is situated. After the house of Jahirul, about 19 other houses. After the incident, about 30% assembled at the place of occurrence. And your lordship has seen in one of the witnesses' deposition that they have not even bothered to even depose to these people that how the incident has occurred. The house of the accused Suhan Ali is situated at a distance of about 200 to 250 meters away from the place of occurrence. It is not a fact that we had a dispute with the accused over seizure of their cows by the BSF. In a suggestion, we tried to build up a case, my lord. It is not a fact that we had dispute with the accused over seizure of their cows by the BSF. 5% from our side and the 4 were accused present place at the occurrence. So 5 persons from our side and the 4 accused were present at the place of occurrence. After 2 days of date of Siddiqui, the police recorded my statement. It is not a fact that I did not tell the police that accused Tahir Ali was holding Siddiq Ali. It is not a fact that I did not tell the police that the accused Surab Ali was wielding a bamboo stick and the accused Hassan Ali was present at the place of occurrence. I have married the widow of Siddiq. It is not that we trespassed into the house of the accused and assaulted them. It is not a fact that to marry the wife of Siddiq, I stabbed Siddiq. It is not a fact that I have deposed Polly. It is not a fact that the incident occurred during night. It is not a fact that taking advantage, I committed murder of Siddiq.
Advantage of darkness.
Advantage of darkness, sorry. The police, the next page, madam. The police had recorded my statement after 2 days of the incident. At the time of my recording of my statement, Surat Ali and his wife and member Anwar Hussain were present. After the incident, my father and the husband of my sister, namely Shobur, had taken Siddiq Ali to the police station. They were not examined. I do not know if the accused were also admitted in the hospital. It is not a fact that we assaulted the accused person and caused injuries to them. Hearing the noise at about 5:30 p.m., I went to the place of occurrence. Now, the next paragraph, your lordship will see, he admits that these were not told to the police. I did not tell the police that hearing a noise, I went to the place of occurrence and saw that the accused Saban Ali was trying to assault my father Asaruddin Mandal by means of a dagger. And Ajibur Rahman caught the accused Soban Ali with the dagger and I grabbed the accused Soban Ali from behind. I did not tell the police that Ajibur Rahman snatched away the dagger from the hands of the accused Soban Ali. It is not a fact that I had illicit relationship with the widow of the deceased Siddiq Ali. And therefore, I killed Siddiq Ali. After the murder of Siddiq Ali, I have married his widow. So this witness was trying to develop his case in the dock, my lord, during the trial.
He's the younger brother of the deceased.
Yes, ma'am. Both PW 2 and 3, they tried to improve their version in the doc from the earlier statement, and they have admitted during cross. Now, PW 4.
How is it disconnected? Tried to be connected, the last 2 sentence, last 2 lines of page 18. The driving of the wife.
It is not a fact that I had illicit relationship with the widow of Siddiq Ali. Thereafter, I killed Siddiq Ali. The suggestion from the defense side was that this Saddam had an illicit relationship with the
Wife of the deceased.
deceased and taking advantage of this scuffle, he is the person who had stabbed Siddiq Ali.
Then after the murder of Siddiq, I married his widow.
Yes.
Okay, that is okay.
Hmm.
It is not a fact that few days prior to the incident, I had driven out my wife from the, not a fact.
But if your lordship looks at page 14, that witness says, after the murder of Siddiq, my cousin brother Saddam married his witness. Earlier, Saddam had married another woman. She has left the house of Saddam. May I read my PW book?
Yes. 19.
Yes, madam. And last one more witness is there, then we can rush, madam.
Ainuddin.
Yes, ma'am.
He was also there.
Yes, ma'am. Ainuddin Mandal, who was hit on the head by Sorab, who was convicted under section 323. I know the accused person. I also knew that this is Siddiq Ali. On 27/9/2013 at around 5:30 p.m. at village Sasterghat, Part 1, we heard that while the deceased Siddiq Ali was returning from village Gaspara towards his house, the accused Sorab Ali had assaulted him. Thereafter, I saw that armed with lathi, the accused Subhan Ali, Tahir Ali, and the mother Ajiran Bewa were proceeding towards the bank of a tributary of the river Brahmaputra. Out of curiosity, I followed them. The accused Subhan Ali, Tahir Ali, and the mother Ajiran Bewa took shelter inside an abandoned house in the bank of a tributary of the river Brahmaputra. In the meantime, deceased Siddiq Ali arrived there. Then, at the instant of the accused Sorab Ali, the accused Subhan Ali, Tahir Ali, and the mother Ajiran Bewa entered into an altercation with the deceased Siddiq Ali. Thereafter, the accused Subhan Ali attempted to stab the deceased Siddiq Ali by means of a dagger. I then caught the hand of the accused Subhan Ali, at which the accused Sorab Ali gave a blow on my hand by means of a lathi. I fell down on the ground. Thereafter, the accused Subhan Ali stabbed the deceased Siddiq Ali from behind by means of a dagger on the right side of his stomach. The accused Tahir Ali was holding the deceased Siddiq Ali. Then the deceased Siddiq Ali fell down on the ground. The other accused also held the accused Subhan in stabbing the deceased Siddiq Ali. One Ajibur Rahman was also present at the place of occurrence and snatched away the dagger from the hand of the accused Subhan Ali. Thereafter, the public took me and the deceased Siddiq Ali to the Dhuri Civil Hospital. As the condition of deceased Siddiq Ali was serious, he was shifted to Guwahati Medical College Hospital on 1/10/2013. Siddiq Ali succumbed to the injuries at the GMCH. The police seized the dagger by which the accused Subhan Ali stabbed the deceased Siddiq Ali in my present. Exhibit 2 is the said scissor list and Exhibit 2 is my signature therein. Material Exhibit 1 is the said dagger. The handle seems to be eaten away by ant. But if your lordship here, although the material exhibit is the said, but in the judgment, I don't find that this was there, madam. At page 83. Maybe out of oversight, I have to also just noticed, but maybe out of oversight, this dagger was not. But the fact is that this dagger, no forensic examination of the dagger was done to ascertain whether there was any blood mark, whether there was any fingerprint of any accused. All these witnesses from 1 to 5, they have not disclosed how this altercation started or what was the dispute. Although in the affair, they said they came armed with dagger, lathi, and sword. But subsequently, during that deposition of the witness, you also will find that they have not stated that we had come armed with dagger, lathi, and sword. Now you also will see the cross. This is Siddiq Ali told me about the incident over mobile phone. At the
Which incident?
I don't know. Not
It
clear.
cannot be this incident.
So
He
I
was
don't-
there with him.
I don't know whether this question remain inconclusive. Answer to this question remain inconclusive. The deceased Siddiq Ali told me about the incident over mobile phone at the place of occurrence beside the accused. I saw Asaruddin, Saddam Hussein, Ajibur Rahman, and Jaharul Haq. This is Siddiq Ali was the son of my own brother. It is not a fact that the deceased, or maybe he, my lord, he told about the incident and he raised the place of occurrence later on. I don't know. This is Siddiq Ali was the son of my own brother. It is not a fact that the deceased Siddiq Ali called me and Asaduddin Mondal, Saddam Hussein, Azam Ali, Jainal Abidin, Majibur Rahman, Amjad Ali, Azir and so to the place of occurrence. And armed with lathi, fala, and so, we went to the place of occurrence. This was the story shot to be made out during the suggestion because
Yes.
the place of occurrence was near the house of Jaharul Haq, PW5. Jaharul Haq was the maternal uncle of the deceased Siddiq Ali. At the time of incident, the accused Sorab Ali and the deceased Siddiq Ali were coming from village Gaspara towards Sasterghat Part 1 by a boat. I do not know how many persons were traveling by the said boat and who was flying it. The place of occurrence was about 100 meters away from the bank of the river. I did not have any land near the place of occurrence. The houses of the accused are situated at a distance of 200 or 250 meters away from the house of Jaharul Haq. At the time of incident, there were 3 residential houses at the place of occurrence. Now some more people have constructed houses there. On 2/10/2023, police recorded my statement. The land of the material exhibited is about 12 to 13 inches.
What is exhibit 1?
This is the they say about the dagger.
Dagger.
12 to 13 inch, they say. The police did not tell me what is written in the scissor list. So I have corrected myself because I was misled by this the list of exhibits I did. Now I have recall, my lord. I'll come to this during the reference to the postmortem report. The length of the material exhibit 1 is about 12 to 13 inches. The police did not tell me what is written in the scissor list. The handle was about 4 inches long. The dagger was seized from the house of one Surat Ali of our village. The dagger was seized from the house of one Surat Ali of our village. The wife of Surat Ali
And
the wife of Surat Ali and village panchayatman Anwar Hussain were also present at the time of making the seizure. It is not a fact that the material of exhibit 1 belongs to us and has no connection with the alleged incident. Suggestion was given that this is your dagger. It is not a fact that I told the police that before the accused Sobhan Ali could stab the deceased Siddiq Ali, I had snatched away the dagger from the hand of the accused Sobhan Ali. It is not a fact I told the police that the accused Sorab Ali gave a blow on my head by means of a lathi. It is not a fact that this is also your lordship will take note. It is not a fact that I told the police that the accused Sorab Ali gave a blow on my head. It is not a fact that the accused Sobhan Ali did not stab the deceased Siddiq Ali by means of a dagger. It is not a fact that after receiving the phone call from the deceased Siddiq Ali we assaulted the deceased Siddiq Ali. After the death of Siddiq Ali, we arranged the marriage of his widow with the cousin brother of Siddiq Ali, namely Saddam Ali. It is not a fact that Saddam Ali had illicit relationship with the widow of the deceased Siddiq Ali and a meeting was held in the village to decide the same. It is not a fact that the police seized the dagger from the possession of Saddam Ali. It is not a fact that the said dagger belonged to Saddam Ali and he had killed the deceased Siddiq Ali. Our houses are situated at a distance of about 300 meters away from the Indo-Bangla border. There was a BSF post at our village. It is not a fact that we used to illegally transport cows to Bangladesh and the accused Sobhan Ali informed the BSF personnel about the same. And the BSF personnel seized our cows and for the same with intent to assault the accused Sobhan Ali, we were charging for him. It is not a fact that we assaulted the accused Sorab Ali, Sobhan Ali, Tahir Ali and their mother. It is not a fact that the accused Tahir Ali was not holding the deceased Siddiq Ali. It is not a fact that I did not tell the police that the accused Tahir Ali was not holding the deceased Siddiq Ali. It is not a fact that I have deposed falsely. It is not a fact that as I am an accused of the case filed by the accused of this case, I have deposed falsely. At least, my lord, in this case, so far the defense lawyer is concerned, at least he is trying to build up by through suggestion the intent and the motive for which the incident took place, my lord, or what is his defense. Page 22, deposition of PW5. This is the last witness, my lord, the others are all official witness. May I read, my?
Just a minute. Johirul,
The house,
hmm?
in which house,
Incident had taken
Oh.
place.
25 meters away from his house.
Yes, please.
I know the accused person. I also know that this is Siddiq Ali. The incident occurred at a distance of about 25 meters away from my house. At the time of the incident, I was present in my house. Hearing a noise outside my house, I went and saw that the accused Surab has given a blow on the head of Ainuddin by means of a bamboo stick. In the meantime, the accused Soban Ali stabbed the deceased Siddiq Ali by means of a dagger, a sharp cutting weapon. At that time, the accused Tahir was holding Siddiq Ali. Then I raised a hue and cry and sent the injured to the hospital. The deceased Siddiq Ali was my nephew.
Yes.
Beside the accused, I saw Ainuddin, Asaruddin, Saddam Hussain, Azibur Rahman, Joinal Abidin, and Mazibur Mandal at the place of occurrence. There were about 100 to 150 houses near my house. I cannot say whether the inmates of the said houses saw the incident. It is not a fact that the incident occurred in my house and not a distance of about 25 meters away from my house. It is not a fact that at the time of occurrence, along with Ainuddin, Asaruddin, Saddam Hussain, Azmar, Joinal Abidin, and Mazibur, and armed with lathi, etc., I was waiting in my house. The accused had to go to the house through the road in front of my house. It is not a fact that on the day of the occurrence, Ainuddin, Asaruddin, Saddam Hussain, Azibur Rahman, Joinal Abidin, and Mazibur assaulted the accused Tahir Ali and Showan Ali in front of my house with intent to kill them. It is not a fact that Saddam Ali had illicit relationship with the widow of the deceased Siddiq Ali and he had killed the deceased Siddiq Ali. It is not a fact that as the deceased Siddiq was my nephew, I have deposed falsely. The police recorded my statement at the police station. Asaruddin was accompanying me and his statement was also recorded at the police station. It is not a fact that I did not tell the police that the accused Tahir Ali was not holding the deceased Siddiq Ali. It is not a fact that as I am an accused of the case filed by the accused of this case, I have deposed falsely. It is not a fact that the accused did not commit the murder, so and so, so and so. So one thing is, my lord, so far this all this related witness from 1, 2, and 5 are concerned. So far that stabbing part, everyone is consistent. But the only thing is that when it is, why they have even consistent, because they know that if they or I don't know what has happened, if the other independent witness in a crowded area or the neighborhood have examined, then probably the suggestion which was suggested during the cross, that real fact would have come out. That's why I think no independent witnesses were examined and they had confined to only these 5 witnesses. And
no, that part we cannot assume.
Yes.
If the number of witnesses which have been produced and the evidence which they have led are sufficient to prove the case beyond reasonable doubt, that will be, it's the quality, not the quantity.
Yes, we appreciate, my lord, we appreciate. It's always the quality and not the quantity of the evidence. And secondly, your lordship has to see that whether there was any premeditation to cause this assault.
No, here the witness of the person who was himself injured will be of much credence.
Yes, my lord. But whether he has spoken the whole truth or partially or the partial truth, that also your lordship has to see. We'll see his
eyewitness. He was there in the assault. He was himself injured.
Because normally, if we presume that normally if a injured witness is there, then he will not like to want to let off go any of the accused who has caused the fatal blow. That's the normal human tendency. But here your lordship will see, so far the witnesses are concerned, I at least don't find that there is any such prior motive or there was some planning to commit such a crime. Because they have not given the actual how the incident occurred. They have all started from seeing it. And in spite of for 3 days, the other person was there at GMCS hospital. They have also not bothered to record the dying
We
declaration.
don't know what was his condition.
No, that they have not brought it on record. We'll come to it, Palat. And
seeing the medical, the post-mortem, he had a big injury on his left part of the stomach.
Well, but,
whether he was in a position to make a dying declaration, those are also matters to be looked into. You may be right.
he would have been, his evidence would have been of grave importance. Person who is on the deathbed is not
Normally will not
expected to
speak
lie.
lie. So now your lordship will see PW 6,
Yes,
who a doctor who has examined the
yes, yes.
one thing is that person has died. Now your lordship has to see whether how the person has died. Although like everyone is saying about this appellant Shubhan Ali, your lordship will see whether it was this injury was caused due to a fight between both the group or not, whether there was any prior concert of minds to commit such act, because that will
You
help
had
you.
lost an affair.
Yes.
You had lost. What is
Yes,
the
yes.
fate of your case?
Well, that instruction I don't have, because I have always said they have admitted in their cross that
Did you lead defense evidence?
no, as per the paper book that I have been funny, has not
No
there.
medical document exhibited by you of suffering any injury.
I cannot. So I have to rely on their suggestion only. I have to rely on the suggestion where
Had
there
it
is an
been- had it
admission
been
by
a-
them.
Had it been a tussle between two groups,
Yeah.
matter would have been slightly differently.
No, they have admitted that there is a cross case. They have admitted that there is a cross case. And they
No,
have also admitted that
they
there
have
are.
not admitted in
Ah.
the cross question,
Ah.
cross-examination. They have said that only because I'm accused in their case, therefore I'm not deposing falsely.
Yeah.
That will not
No,
give
but
any veracity.
actually, I have the copy of the cross FIR laws.
But nothing
certified.
beyond that.
Your lordship, I cannot go and teach the council there how to. Your lordship has
No,
seen.
no, but did you suffer any injuries?
My lord, the I'll just check once. That's the main problem when you argue a criminal appeal. I'll just give you a lot to it. But she's taking out, I will just.
You read the doctor's examination?
Yes.
He had,
Yes, I have the just check.
he had examined Ainuddin. The,
Just a-
he had injured, he had
Yes,
examined the
okay.
injured, not the, I think deceased was, did he look into the deceased also?
Yes, my lord, day one at Dhubri, my lord.
Okay, okay. Oh, both. Okay, I examined Ainuddin as
Yeah.
Siddiq, both.
Ah.
Okay.
Just a moment. Good. Line to that put us underline no quickly put here. Injured physically put it. Both the group has said that 30,000, that money part which was narrated in the FIR, they have also in the cross FIR said about taking away. Injury for the in the cross FIR also it says, but while seizing the dagger from that person, he had suffered injury in his hand. This is the certified copy of the FIR. But although it may be a certified copy, I don't think your lordship can now look into it unless it is exhibited. But in the bail order, I have seen that this division, honorable division bench, coordinate or bench of this court has even looked into the 161 statement. That also, I don't think your lordship can look into it because.
No, those have already been examined by the trial court.
Yes.
Cross-examination put on the basis of
And the
161.
contradictions and all, we have to put it in accordance with law. But the problem in most of the cases, your lordship will find the cross-examination or the contradictions are not even put up after so many years and so many judgments as required under law. This cross FIR they had the certified copy of the cross FIR. Even if they had was not willing to give it as a defend witness, they could have brought it during,
Concentrate in the, in the
yes, during cross-examination only, they could
cross-examination.
have got it exhibited.
Okay,
That's,
PW six.
yes. Because I can't concede nowadays because all are live streamed. But only only thing is that, my lord, said my endeavor will whether I have to talk in the legal language, that whether I can put it in on one of the exceptions for that it is not premeditated, and that it was a group fight. Their side was also 5. This side was also 4, and it occurred at that moment of time. And so far the witnesses are concerned, they are not trying to, these eyewitnesses are not trying to give a true account of the events that have unfolded. That only I can say, so that now, because now, even in during, now once this live telecast of this cross-examination will start, there will be a lot of cases where they will say that I have not even authorized the counsel to put this suggestion on my behalf, because admission, if there is an admission in the suggestion that this has taken place, that can be used against the accused. So it will become very difficult. Maybe they are watching me in Tiburon jail. Well, PW6. On 27/9/2013, I was posted at Civil Hospital Dhuburi as SDGM head office. On that day, examined Ainuddin Mandal and Siddiq Ali on police record. On Ainuddin Mandal, I found one lacerated injury in the scalp. Lacerated means makisal. Injury in the scalp. The size of the injuries was so and so, so and so. In my opinion, the injury was faced less than 24 hours, simple in nature, and was caused by blunt object. Lathi, it's possible, my lord. On Siddiq Ali, I found one penetrative injury on the right loin. The size of the injury was 1 inch.
Half inch by 4 inch.
Yeah, medical was to be controlled. Just a moment. I found one penetrative injury on the right loin. The size of the injury was 1 inch and half inch and point. In my opinion, the injury was fresh, grievous in nature, and was caused by sharp pointed open. Exhibit 3 is the injury report prepared by me, and Exhibit 3.1 is my signature, and Exhibit 3.2 is so and so. The injured Siddiq Ali was admitted on the same day and was referred on the same day to the GMCS. I did not mention the blood pressure and pulse in my injury report. Finding internal injury, I referred the injured Siddiq Ali to the GMCS. I do not remember what treatment I had provided to the injured Siddiq Ali. I do not remember whether the injured Siddiq Ali was in a condition to speak or not. I have not mentioned about the history of the injury. I have not mentioned in what condition I had referred the injured Siddiq Ali to the GMCS. I have written about the size of the wound as 1 inch, half inch, and 4 inch after probing the wound. I have not mentioned the same in Exhibit 3 injury report, how I have examined. It is not a fact that I did not treat the injured Siddiq Ali properly. The injury found on Ainuddin Mandal may be sustained due to falling. The injury found on Siddiq Ali cannot be sustained due to falling on any hard surface. I do not remember whether I asked the injured Siddiq Ali how he had sustained the injury. Your Lordship will see this Exhibit 4, the injury.
Exhibit
4.
Page?
Three is the injury report.
Page.
Just a moment. It is there. At page 86. Now, if your Lordship looks into this injury report at page 6, your Lordship will find that he was admitted on 27/9/2013 at 8:20 p.m. and discharged on 1/10/2023. And now your Lordship has seen that it is a simple injury.
No, not simple. Siddiq.
No, not Siddiq. I'm talking about Ainuddin Mandal.
And yes,
Ainuddin Mandal, simple,
simple.
but even then he was kept in the hospital for 4 days. Was he unconscious or was there any injury? It's not reflected, but simply it is said that it is simple. Now your lordship will see laceration in the scalp. The scalp is
No, this appeal is the conviction pertaining to deceased Siddiq Ali, isn't it?
yes, ma'am.
Let us
Yes.
concentrate on Siddiq
Your
Ali.
lordship will see laceration in the scalp.
Hmm.
1 inch into half
That
inch
that
into
is Ainuddin.
yes, Ainuddin, laceration in the scalp. But the exact location is also not mentioned. Your lordship will see only it is said the laceration in the scalp. Phase less than 24 hours, simple in nature, caused by blunt object. Then Siddiq Ali, your lordship will find penetrating
Injury.
injury in the right loin. Size is shown, press, grievous, sharp pointed.
Hmm.
So, but it doesn't say that if there is a penetrating injury, with that injury open, it was sent to Guwahati Medical College Hospital, or whether this penetrating injury was repaired. That has not come out in the evidence. If you have a penetrating injury of this side, due to blood loss also you may die. But it is not said whether it was repaired at Dhubri. Total report. Postmortem report itu. Postmortem report. Nah, nomor apa kita? Ya, apa? Liquid dulu deh. Postmortem report. Itu, itu, Postmortem report tak. Please. Betul tak. Saya lihat mulai tapi postmortem report tak. Tahu dia. Tahu kalau kita cek cek dulu. Postmortem report dia tak. Mana lagi tak? Ya kalau betul. Right. May I read the next witness, my lord?
Yes, Sumant.
PW7, the investigating officer who recorded the statement of the witnesses, my lord. On 2/10/2023, I was posted at the Bazaar.
Just a minute, please.
Yes.
it should, if you come to the page 97,
Yes, ma'am.
so far as whether any treatment was given at the hospital at Dhubri,
Yes, ma'am.
page 97.
Yes.
Part of the postmortem, number 1, external appearance. First line itself, male dead body of so and so, with surgical pad and bandages. Then come to the second one, wounds, position and character. Surgically made stitched wound.
This, this surgery was conducted where? It's,
Surgically, but there
No,
are some
there,
sub.
if you're also, the number 3, each punctured one of so and so, so and so. It was repaired. So, was it repaired during surgery, my lord? Then if it was not done, then why the surgery was done?
Teeth punctured wound, so and so.
That is, that your lordship has rightly pointed out, but was it repaired during surgery, my lord? This one.
Then when? When will
That
it
is
be
one.
repaired?
Then why does, then,
Now,
if-
when will it be repaired then?
well, that's not clear.
No, it has to be repaired during surgery only.
Yes, my lord. Then why this surgery was done, my lord?
Because of the stab injuries.
Well, who?
That's just a minute, please.
But the postmortem doctor has probably not done it, my lord.
8, 9.
This is the doctor who has conducted the postmortem.
When did he pass away?
On 1st, after 3 days, 27th, he passed away on 1st. During this intervening period, surgery probably must have done, but it's not clear who has done the surgery and when. The postmortem.
Either at Dhubri or at Guwahati.
Yes.
Guwahati doctor has not been examined.
No. So, because if the Guwahati doctor was examined or there was some evidence, probably they were trying to not to disclose it by, because sometimes what happens in this type of wounds when it is stabbed, then septicemia may develop and person may die of septic also. Then there are cases where persons have, if the death is not directly immediately due to the result of the stabbing, there are cases where this has been converted from 30
No,
2 to
that
3.
part will not be possible because you see the opinion of the
Yes, opinion I have
at
seen. my-
101,
Yes,
not
yes.
because of septicemia.
No, my opinion is, my lord, it
That
may-
was due to hemorrhage and shock as well as the stab injury as described so and so, which were antemortem caused by pointed weapon and homicidal in nature.
No, my lord, this, again, your lordship will see, if you say that it's as a result of this stab injury as in, which was antemortem. Normally in stab injury, there must be loss of blood. Or it must have hit some vital organ for which there was rupture and all. Normally it is a loss of blood only which, but in nowhere in the postmortem report or in the doctor's report, this loss of blood was mentioned. Neither during the cross-examination of this doctor, there was no effort made by the defense to know the exact cause of the death. This is simply an opinion, my lord, that it was caused because they had this
No,
briefing.
In PM, how do they say about loss of blood? PM, they're only examining the course.
No, by looking into the color of the body, the time of death and all, people can make out by loss of blood. Or there can be an estimation by looking in the inside of
We
the
have not
body.
come across any
No,
any PM report where there is any opinion regarding loss of blood.
No, but there are cases
Yes,
where
rigor
the
mortis,
Right.
what is the color of the body?
injury. No,
Those are
loss
there.
of blood is there. Even if your loss will find in case of deep cut injury, if there is clotting inside that wound, then it can be made out how the wound has been inflicted. Or even if in the stomach there is full of blood, then also it can be assumed that it was due to this wound there was flow of blood in the stomach. That's why the person have probably died there. Because these are this
Here it is there at page 99. See the abdomen, number 2. Peritoneum, punctured with scissors. Then clotted blood present 750 ml. There is
Your lordship is reading.
99.
Just a minute.
Serial number Roman 4, abdomen.
This punctured with scissors, mesentery, confused, clotted blood present.
Clotted blood,
Whether this
750 ml.
clotted, this blood which is clotted, whether this is the blood which is present there during the surgery or it is due to the injury, that is not there.
It's clotted blood means the blood.
It can also happen during the surgery also.
Surgery, what surgery? There was no
They have
surgery.
said that they have done the surgery.
It's a stitch.
Stitch only. Means during the stitch also, if this stitch is not done properly, there can be so many reasons blood can come out. This clotted blood present doesn't suggest that it is due to that particular stab injury. This clotted blood is there after 3 days.
See, with a stab injury of 3.5 into 1.5 into 4. Blood loss, he has died of blood, 750 ml of clotted blood
Yes, madam.
found inside the abdomen. Okay, yes, next.
But your lordship will see, kindly appreciate this clotted blood present. This can be for various factors. You cannot say directly, your lordship will not, cannot attribute that this 70-50 blood which is clotted and present is due to the stab injury.
Then for what?
Well, there was a surgery done. There maybe, I do not know, but they have not produced those evidence. Some blood transfusion may be there because the doctor's report of GMCS is absent so far this case is concerned. 3 days, after 3 days, my lord, how this blood is there, just because in the opinion of the doctors who conducted the postmortem, he has seen clotted blood present 750 milliliter inside the.
What was the cross-examination? What did you?
No, welcome, my lord. Your lordship will first look in.
Come to page 31.
Yes, sir.
Did you put any cross-examination? Did you put any question? Page 31.
I've seen.
That is only question, that whether such injury can occur by falling on hard or sharp substance. He said no. That is the only one line.
No, I cannot develop because
No.
this is ignorance. This is ignorance of my brother who had done the cross-examination. Probably he has never bothered to read the medical jurisprudence or the how a doctor has to be cross-examined when he gives the postmortem report. This is a because if this person was if he was a person who could have had the best of lawyers in the country, probably his cross-examination would have been elaborate and all these facts could have been dissected. Well, that's why your lordship, we always. Just off the remark. My problem with I have seen, your lordship has seen also, when doctors are cross-examined, you should at least read some books on medical jurisprudence to how to our Modi's. There are so many books on medical jurisprudence. These are not part of our LLB curriculum. We don't bother to read it. We don't know the difference between abrasion, laceration, and what is the differences between bruises, laceration, and abrasion. And you go and do a cross-examination of a medical expert.
Okay, next.
Now you'll also will see PW7.
Page
26. You'll also just say the improvement made during,
Oh, আপনার single bench আছে। Sorry, এটা বন্ধ করুন। We'll continue till 4:15. Sister has got a single bench, some matters, then we'll meet, continue tomorrow, wherever. 26.
yes. Asaruddin your Lordship will omit this, he is just the IO, nothing is there. I went to the, now your Lordship will see the improvements made during trial. Asaruddin Mandal did not tell me that accused Tahir Ali was holding the deceased Siddiq Ali by his neck. This is in regard to PW1. Then PW2, Ajibur Rahman told me that seeing the accused Subhan Ali attempting to assault his uncle Ainuddin by means of a knife, he snatched away the knife from the accused.
You are reading at this.
Page 27.
Sahidur.
Yes,
Sahidur, he was the
IO,
police
IO.
officer. I see.
police, IO.
Okay. Is the knife sensible from service? Warrants of the-
PW2
for-
process.
161.
অসমীয়া PW2.
They did not tell me.
No, কাক দিয়া আছে।
How many witnesses total?
10,
10. How long will you take?
another half an hour. We can continue tomorrow. No.
Tomorrow. By half an hour, I'll be able to complete.
I think because my I have to be fair to as an officer of the court. I have said that.
How much time?
Maximum half an hour, not more.
Okay, we can have it at the first item tomorrow, subject to if new matters are there.
Only thing item number 1, I have I have some other court.
No, we'll accommodate you.
As soon as I finish, I'll come.
Don't worry. We'll give
I'll
preference
inform the
to
court master.
We'll give preference to this matter.
Well, my only thing is that I cannot answer, but my endeavor in this case is to see that whether I can make it fall under 304 part 2. That is only my endeavor. I will not say because so far the person has, because of this faulty or his deficient cross-examination only, I have to concede to that extent. But as a senior counsel, I cannot concede. I always have to make an endeavor to go for full acquittal. But still, I'm trying to make an attempt to see that whether I can make it fall under 304. And under the exception, court exception of 300. That's it. One I know. Go back.
Oh my God. Have one, huh? Correction पे पूछे जी बेटा। थोड़े कौन सा से कौन दूसरी लिखी।
Only that's 304, my lord. Your lordship has stated not. Culpable homicide is not murder if it is committed without premeditation, number one, in a sudden fight, in the heat of passion, upon a sudden cruel, and without the offenders having taken undue advantage or acted in a cruel or unethical. This is the only way.
Fight, we are equipped with daggers and lathis and
Well, both
swords.
sides, both sides.
No, they did not have any.
No,
They had only snatched from you.
but they already.
Okay, we'll see, we'll see. Order list for further consideration tomorrow.
My lord, item number 8, the next item number 8, 12 years conviction, more than half of the conviction he has undergone, my lord. It is an appeal is pending, my lord. If your lordship kindly takes it on Thursday, I'll not take more than 15 minutes. My lord.
Under conviction
Under NDPS, will not take more than 15 minutes, my lord. If they after tomorrow, more than half of the sentence he has undergone this. Day after tomorrow, my lord.
After tomorrow, how many witnesses?
7 witnesses, my lord. My lord, I'll complete it within 15 minutes. I'll stick to my word, man.
We can have a try, but not may not be possible. May not be possible on Wednesday.
No, on Thursday.
Thursday.
If tomorrow the roster is.
May not be possible. We can try, but may not reach, because as you know, if one appeal will take some time. It's
Tomorrow, day after tomorrow. Yes.
Thursday we'll try. Okay. Okay.